Test 1 2 test 1 2 test 1 2.
Okay, I'm going to call us to order. I think it's 6:30, and my watch is 6:30. No? Oh, wait, your clock is I'll wait till your clock is. All right, okay. So, we're going to have the Pledge of Allegiance. So, who hasn't led it? Have you read Barnes? All right, Barnes I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
roll call.
Bill Judge,
Present.
Ken Hayes,
Here.
Ron Bell,
Present.
Sue Ford, here, Ted Miller,
Present.
Norman Turner, here, Eddie Roth, here, Steve Burke,
Here.
Linda Marcus, Glenn Wiggins, Connie Bonet, present, Robert Christensen, present, Ron Black,
Present.
Mike Doherty, John Corso.
Here.
You all have the agenda in front of you. Does anybody have any modifications you want to put on the agenda? Hearing none. Oh, Noah?
Well, I thought that you had talked about the fact that we were going to change our structure, and I don't see that on here.
That's under subcommittee report.
That's under,
On
okay.
the subcommittee report, we'll talk about all of that stuff. If you want, we can put it as a separate item. You want it as a separate item?
Well, I think so, because here we're talking about articles, and that was a separate thing.
So how about if we have it after issues to bring to public hearing? Because that's how we do it. Okay, and how do you want to word that?
Revisit subcommittee.
Okay. Okay. So we have an addition to the agenda, so Nola, keep me honest and remind me that we've added to the agenda when we get there. An item called revisit subcommittee structures, I guess.
We're not having trouble here, we've got a lot of outside interference here.
Okay. Remember, for the audience, if you want to talk, you can. You just need to go out in that room or that because it really interferes with recordings, and then they don't come across too well. Okay, so the agenda item that we're adding is revisit subcommittee structures. Is that what you're asking for?
Do you have a microphone?
I do.
Okay.
Okay.
Yours are best.
So revisit subcommittee structures. Perfect. All right. Anybody, any other modifications to the agenda? Hearing none, someone want to move for adoption of the amended agenda?
So moved.
Moved by Nola. Seconded by Maggie. Those in favor? And opposed? Adopted. Okay. So, did you all get your minutes in time to read them, or do we need to put that off until after the break?
I did not get them.
Is there anybody else?
I have extra copies.
Okay. While we come back to approval of the minutes, Trish, do you have correspondence?
I have one from Susan Schottefer that is a submission for last Monday, proposal for transparent contract negotiation between county officials and union employees. And a proposal to make union membership optional. I have a YouTube link from Stephanie Nolan for the 420 meeting. And I forwarded several links from Brian Boreen. One is
Any questions to Trish? That's why our downloading time was 96 pages today. Okay, public comments. It's the sign, if someone will hand me the sign-up sheet. Remember, it's a 3-minute timeline. We're going to be really rigid about that tonight because we have a big agenda. We have 2 people who need to leave early, so we'll start with Carol Johnson. Thank you.
Carol Johnson, I'm Executive Director of the North Atlantic Timber Action Committee, Post Office Box 1057 in Port Angeles, and I'm here to urge you to move forward one of our suggestions, which was the reconveyance of our forest board transfer lands to the county for management. There are a number of ways that can be managed, either by a private contract or by hiring a staff forester to oversee those acres. We think would be in the best interest, at least financially, of the county. And also, if you do not move it forward on this go-round, it takes several years if you were to do it this time. It's going to be several years before anything would even develop where we would know if that would take place. So if it were not moved forward on this charter review, it would be nearly a decade before it would come up and we'd have any hope of doing something with it again. The time is right, and I think it's a good item to consider. Thank you.
Thank you. And next is Williamson. Okay.
I'm Ed Willison. I live at 1719 East Lambert Lane, and I'm here to speak for the Justice Restitution here. We have prepared a proposal for you, and in that proposal we have a preliminary budget, which is nothing more than expenditures. And I'd like to explain that as we get to the end, but right now I just want to tell you that in the preparation of this, we made sure that we stayed within the guidelines of the RCWs, so that everything that we have could be supported by that. And one of the other things that I would like to see a grand jury taking in, there was 2 instances. One was when a highway patrolman turned in front, it's been about a couple of years ago, turned in front of a vehicle and caused a really horrific accident. And it's difficult for people to expect their employer to do a non-biased job of investigation. And I think a grand jury at that time would really have been beneficial. The other one was, we have an elected judge here who asked one of the people who he was sentencing to sing Itsy Bitsy Spider. So to get one of her counts down or lowered down so she didn't have as long to serve. And in that, she sang Itsy Bitsy Spider, then he noticed there was children in the audience and he asked if they were hers. And she responded with yes. And he said that he would like to have them also sing Itsy Bitsy Spider. And she said, no, I refuse to do that because you will not humiliate my children. Okay, now we're going to go over to the budget, projected budget, and I know you can see the figures and they're going to make you a little confused, but that's why I'm here to explain it. The first one is on the per diem charges. You see the figure is $750. Well, it's difficult to determine exactly how many hours right now the grand jury will have in session. They have 6 months throughout the year. They'll be in session for 6 months, and then if they get called back, they can serve another 6 months. But you don't know how many times the jury will be called. So I had to estimate, so I estimated it's about $750. The other one that you might question is the admin, and that is scheduled for full time because you're going to have somebody who's taking care of the paperwork, who's going to make sure that the calls and everything are answered and everything is copied and protected and all of this. And if you'll notice some of the others, we've attorney fees, we've got 10 hours because we don't know what kind of case you will draw, what it's going to take to get for them to look at it, to get us, make sure that we stay within the guides of the law. And an investigator, we do not know if we're going to have that on each case. You may not need an investigator, but you may need one. Oops. Okay, well, thank you. I guess I'm supposed to.
Thank you.
Thank you.
Judy Handgardner.
Good evening. I'm Judy Handlertner. I live at 1815 East 4th Street in Port Angeles. Justice Restoration of Clallam County would like to thank the Charter Review Commissioners for giving us this opportunity to speak to you tonight. You have before you the Clallam County Grand Jury proposal. If you were called to serve on a jury, would you know the difference between a trial jury, also referred to a petit jury, or a grand jury? Here are the main features of two types of juries in a nutshell. What is a trial jury? The trial jury has 6 to 12 members. The role is decided whether the defendant entered the plaintiff's civil case or committed the crime as a charged criminal case. Trials are generally public, but jury deliberations are private. Defendants have the right to appear, testify, and call witnesses on their behalf. Final outcome is a verdict of favor of plaintiff or defendant in a civil case or guilty or not guilty in a criminal case. What is a grand jury? The grand jury has 16 to 23 members. The role is to determine whether there is a probable cause to believe that an individual has a committed crime and should be put on trial. Grand jury proceedings are not open to the public. Defendants and their attorneys do not have the right to appear before the grand jury. Final outcome is decision to indict, formally accuse the defendant or not. Let me close with this. Let us never forget that government is ourselves and not an alien power over us. The ultimate rules of our democracy are not a president and senators and congressmen and government officials, but the voters of the country. And that was Franklin D. Roosevelt. Get informed, get involved, but most of all, get inspired. Thank you.
Susan Schaffer.
Susan Schaffer, 214 Andrew Boulevard, Port Angeles, Washington. 2 weeks ago, objecting to expansion of citizens' freedom to protect liberty and property with 2/3 voter approval for tax increases, an opponent advised we should trust our commissioners' spending decisions. She affirmed majority rule as fundamental to democracy. How so? Beginning with the premise that humans possess an equal natural right to life, liberty, and the product of their labor, entitlement to protect these vital freedoms becomes intrinsic. Embracing this premise, 110,000 Union soldiers died in battle, consecrating equal natural rights. If we agree with this premise as an extension of self-esteem, isn't voters' most critical task of selection of representatives foremost dedicated to protecting our lives, liberty, and property from criminal acts? If a majority of neighbors identify a neighborhood need, do they possess authority to seize funds from disagreeing neighbors to help eliminate this need? If they could acquire government-sanctioned privilege to force their neighbors to pay, would this be ethical? If majority rule enables majorities to rule others, what happened to equal natural rights? If taking the liberty or property of another is immoral and criminal when committed by an individual, how does this act become moral through majority rule? Do majorities acquire superiority to rule over us, or only possess moral authority to decide who governs or issues not encroaching upon equal vital freedoms? Do elected representatives acquire privilege of superiority to rule over our lives, liberty, and property, or only possess moral authority to decide on issues not violating equal natural rights? Today, with majority rule, legislators routinely pass laws encroaching on equal and inalienable rights. Their rules serve scarcely better than dictatorship. Jefferson wrote, "Democracy is nothing more than mob rule, where 51% of people may take away the rights of the other 49%. Franklin advised, "Democracy is two wolves and a lamb deciding what to have for lunch." Only individuals possess a conscience. Majorities, mobs, Wolves and commissions do not. When majority rule violates equal natural rights, this construct becomes a euphemism for mob rule. In addition to self-defense and local law enforcement, 2/3 voter approval for tax increases, though imperfect, provides more equitable means to protect liberty and property.
Thank you. Is there anyone else who didn't sign up that would like to speak? What I will do is we'll put this back on the podium for anyone who wants to make a comment of the second round of public comments. Thank you. Okay. Financial report from Barb. I'm sorry, I did not have a report. Okay, well, we're still on the budget, right? Yes, we will. Okay. On the subcommittee reports, thank you all for working so hard to get the things in on time, and Glenn got his stuff in, it just didn't get attached to the right thing, so it's here. But what I did today, I gotta find it, you'll have in front of you, it's called a synopsis of items. So today I tried to go through everything that came out with today's paperwork, everything that was submitted at last meeting's paperwork, and came up with a list of issues that all the articles want to discuss on moving them on to public hearing. If there is something left off, it's a sheer accident that got lost in my volume of paperwork. So feel free if something needs to be added to this, you can use this synopsis for discussion, or you can go back through your paperwork and pull out the original reports, whichever is your preference. Just trying to make it easier than flopping through some papers. So we'll go ahead and start with Article 1, if I don't hear any complaints. Remember, the rule that we're looking at tonight is what are we going to move to public hearing? And it's going to require 8 votes in order to move it to the public hearing agenda. Even though, as we mentioned before, the public hearings, anybody in the public can raise any issue they want. They are not constrained. But we will try and frame things of issues that we think are of most importance. If you look at you have 3 pages, so sort of keep that in mind. We're trying to keep a reasonable number of items that we are sending off for discussion. So with that, why don't we just take all
I see 4.
Huh?
I see 4 with Glenn.
No, Glenn's was incorporated into Article 12. It's the 3rd page of the synopsis. Trish did her little magic and took the page that Glenn distributed here and put it into, so it's part of the 3-page.
Madam Chair,
Yes, ma'am.
I would like to move that all of the concepts presented on these 3 pages, with the exception of other issues at the end, and move forward to public hearing so that we can hear from the public.
Moved and seconded that we take the entire 3 pages, everything on here, and move it to public hearing. Discussion. I personally think it would be a little more robust if we had some discussion. So, Mr. Clark.
I would agree with the motion, but for Article 12, the number 7 bullet. There, the committee said we couldn't move the grand jury issue forward until we had more information, which we said was going to be forthcoming. I don't think the committee's made a decision on that. We got that tonight. I would like to put that under other issues where it's at. The way this is worded, it shows up in 2 places. So the maker of the motion, my question is, you said except for those things, other issues, and would you read that as being another issue or part of the motion?
Is that a friendly amendment? Is that what you're asking?
Well, I'm trying to understand whether
Clarify the question.
Yeah, I'm trying to clarify, because 7 says we won't do anything, we get more information, and the way the motion was worded is that we do them all, but for the other issues. I just want to make sure if 7 isn't included, it makes sense, and we can talk about those other issues after the motion's been voted on.
I'm willing to make that friendly change.
So your intent in your motion is to not include number 7 under Article 12?
Correct.
Is the seconder
Yes.
As long as we put it in under other, so that we can discuss it.
It's already under other.
Gotcha.
Ron?
Yeah, so I read everything last night, and I certainly appreciate this summary, but this is the first opportunity that I've had to review it. And so that's a little bit of a tight time frame. And so if we just carte blanche this and accept it without an individual discussion, perhaps of the articles, I could cite one example here. In Article 1, should the county charter add the right of privacy in one's personal affairs and assurances that the county and its officials will ensure that such right is recognized and protected as established by the state and the U.S. Constitution. I did not check the state, but the U.S. Constitution does not have a right of privacy that arose out of case law. Griswold v. Connecticut in 1965 was the principal case. And so is it something that we want to put into the charter when it's the law of the land as interpreted by the Supreme Court? I mean, if we just say everything is carte blanche going to go, we do not have the right to discuss it, an opportunity to discuss these issues.
These are merely concepts at this level, and since these items came from the public, I believe we owe the public the opportunity to speak to them at public hearings.
Barb?
I would just like to clarify with the maker of the motion, are we going to be excluding the forest or trust land?
We're excluding all the other issues.
But number 3 under Article 12 says, should county trust lands be returned to county control and management for the purpose of improving economic contributions?
Okay.
So I'm asking for clarification on that.
Okay. Okay, you can respond to that. Is that your intent?
My intent is that that item be included under other issues.
But no, she's talking, no, we already said you didn't want 7, but now she's talking about 3 under Article 12.
Trust lands. Trust lands is up in Douglas Street. She wants to include this. We're not going to be excluding trust lands. Thank you.
Glenda?
I don't believe we should exclude number 7 under 12. I think we should. There's been a lot of testimony about this issue, and I think I would like to propose that we ask the public whether they want to see some sort of implementation and enforcement provision, maybe a little bit more general than the grand jury concept, and I do think we need to put that forth in, going forward, implementation and enforcement of the charter, or as a grand jury. I think we should go forward with this issue as a public input.
Then you'll need to make that as a separate motion after we've dealt with the motion that's on the floor, because the maker of this motion already deleted it. So that, Ted?
Yeah. I'm opposed to the motion for this simple reason. We've got a huge number of projects here. If we go forward with public hearings with all of them without doing any kind of civic work at all, we're going to be here for hour after hour after hour. There's no way we're going to be able to get anything done within 3 hours. I think we have to do our job and winnow these down a little bit. Some, in my opinion, are clearly beyond the scope of the CRC, and others are really more policy issues which should go to the county commissioners and not the CRC.
I would just interject, remember that when the public comes to the public hearing, they'll have 3 minutes. And if we're given them 30 topics to give us input on, that will be a real challenge. So I just think, for me, it puts an unfair burden on public comment to give them this big a laundry list and expect them to do it in the 3 minutes that we allocate for them. So other comment, people who haven't commented, Noah?
I would like to speak for the motion. I believe that all of these concepts were brought by the public, and I don't think we should be so honed in on the number. I believe I was told earlier that if we have more than what will fit comfortably in this election, we can flesh those out and have them done next election too. I think all of the concerns that are brought by the public here should be moved forward.
sure that all are brought by, for an example, the Article 7, replace Section 750 in the event is really from the county auditor, as I understood it, because we no longer have independent candidates, but that she preferred to see the language changed to states no party preference. You know, and I certainly have no problem with listening to the public, and they should definitely have to say, but some of these may have come out of the committee. I just, without a more thorough analysis, I can't say whether they're all public or all committee items.
Mike?
So I have the same concern. I know some, I can't think of them right now, but some, when we discussed them in the subcommittee, they were not from the public. They were brought by other people. And to be honest, it's just my subjective opinion that many of these are from people who don't like government, don't trust government. And so there's some very ambiguous concepts that if a citizen asks me what they mean, I might have a hard time explaining because they weren't my concern. And as I expressed in a couple of our committees, I don't want to vote to put those sort of concepts forward if we don't firmly understand, can't explain to the public what those concepts are about. And there's a lot of ambiguous language in several areas of this 3 or 4 page packet. That in the subcommittee we had a hard time discussing what they meant. How can we go to the public when we can't answer what we put before them? And in a way, because the committee is putting those forward, there is an implied message that these are serious matters and we should seek the public opinion. And it may, to some people, think they should be passed. From my point of view, they shouldn't be passed. I trust government. I don't always trust the officials sitting in government, but I want to be supportive of people that hold the position. And so, you know, it's a quandary. Some of these are really more sort of Tea Party-ish, I'll say, for lack of a better term. And so, in my mind, they're not, if people want to generate their concern at the public hearings and bring those items forward themselves, great, because many of them did not come from the public. They came out of individuals on the committee, and they had certain historic reasons why they were upset with government.
Ron?
Well, I guess I go to the adage that we're just going out to the public to give their comment on what we've been doing. And if we are out there saying, we, the Charter Review Commission, have heard all these things, these are the ones we've heard, we've tried to formulate where they'd be in the charter. We'd like to understand your position, your understanding, your preference, your ideas, your dislike, your love for these concepts. And then I think we then get to make hay in July. And we'll see which ones, you know, grew, which ones were pulled, which ones were cut short, and which ones were weeded out through that process. And then the committee, you know, the whole will say, okay, well, you know, there may be 46 people who really like the word cooperation to coordination, but we have 4 people who have written a brief saying that that won't provide what we think. Where do you want to vote on that? That's why we got elected. So I think having a public hearing on as many topics as you want makes sense to me. It gets the issues out there, it gets people talking about them beyond the 10 or 12 that are attending meetings, and see what people think.
I would just say that one of the problems I have here is that, for example, under Article 2, it says that the committee, that's not a public hearing issue. It's asking us to refer something to Mark Nichols. And I don't even know what it is they want referred to Mark Nichols.
Well, is that the result of the way this was summarized? The committee report was summarized?
I cut and paste. I went through and took everything that went out to you that came in from the committees, and I cut it and pasted it on here. So that was part of the Article 2 report.
I think the Article 2 report, if I remember correctly, Madam Chair, said items to go to public hearing and either items to be considered by the committee. And under the other items to be considered by the committee, my didactic memory for pages is relatively good. Had underneath there, asked the county prosecutor to review the Yakima voting cases to determine its effect on Section 2. So to me, that was not, I mean, we can leave it here, but I don't think that was one of the proposals from the committee report with regard to what should be going to public hearing.
And I was trying in the synopsis, excuse me, just let go, I was explain. For the synopsis, I was trying to be complete. So maybe this is a problem for us to adopt this synopsis, because it looks like for Article 2, it's not totally accurate. So perhaps what you may want to do is go back to the original reports and adopt by article, because I personally don't know what that's about, and it's not a public hearing comment. So I don't know if the maker of the motion wants to withdraw number 2 out of Article 2 or what. Because it's not a public hearing issue. It's a request for legal opinion.
I have no problem withdrawing that from my motion
And put it under other issues.
and put it under other issues.
Ken?
Well, I had a comment, but I guess I was thinking all of a sudden I'd like to be reminded of what the motion actually was. Could it be read back, please?
Correct me if I'm wrong, but the motion is that we adopt basically this handout for Articles 1 through 12 minus number 7 on Article 12 and minus number 2 on Article 2. Is
Okay.
that,
That's fine, that's what I thought, I just wanted to make sure.
is that the 2 items? Did I miss one?
Yes.
Okay,
I would like to speak to the motion, if the motion's still on the table.
it is.
It is.
I'm opposed for many of the same reasons that have already been mentioned, including the fact that I'm absolutely certain some of these things don't belong in the charter or aren't relevant to what we're trying to accomplish here. And I guess I'd like to make sure and be clear about that. I may be wrong, but it seems to me we should only be bringing things to a public hearing, items for consideration, actually items for input at a public hearing that are legitimate items for consideration as changes to the charter. And I think we need to be certain of that, otherwise we're just creating confusion, chaos, background noise that makes it even harder for us to do our job. So I'm opposed to the motion for those reasons. Although I agree in general with what Rod just said. I think we should bring all the legitimate issues or questions about changes to the charter before the public, at the public hearings, as long as those are legitimate items for consideration. The rest of my case.
Anyone who has not spoken to this motion? Let's see, Glenn, Steve, John, we haven't heard from you. Do you have any comment? Do you want to just...
I just tend to agree with Ken on this one, that we could do it.
Microphone, please.
I just agree with Ken on this one, that we just do the win-win process now and maybe get some of the chaff out of here that's not, doesn't belong here.
I agree with that. I think our job is to win out.
Steve, weigh in?
Actually, I could go either way, but I would, in a perfect world, I'd like to see, instead of all of the detailed wording of this, is more of have topics short and simple on each article. So talk about this topic and not necessarily specific language or anything. So because I think if we can people this, it's going to be complicated.
And
So
that,
it'd be nice if each one of these was reduced down to a topic.
and that would be an option. That could be an option. Okay. Noah, and then I think we've heard from everyone. You're okay, we'll go for the vote. Noah?
I really concur with most of what Rod said. My thinking is that we were told to make these very concise, limited concepts, that we would be fleshing out and making these clearer for the public later. This was not my intention when we were working on that. We would come up with something very abbreviated.
Okay, thank you. If I see no other, thank you very much. Those in favor of closing debate, raise your hand, make sure we have 2/3. That you're voting to close off debate, move to the motion. Okay, thank you. So, clearly we have enough, so we'll call for the vote. Those in favor? Well, we're in favor of the motion to do the whole.
Are we raising hands or something?
You are, please. It makes it easier. 1, 2, 3, 4, 5. Is that right? Okay, those opposed? Thank you. Motion fails. So with that, I think we'll just move to doing it, do you want to just do it article by article?
Sure.
What, Ken?
Well, I wanted to pile on something Steve said that I think is important, and I actually meant to try to say, but I rambled on, and that is, we really really should have a simple bullet list of concepts or concept titles. And I think that's important for the particular reason that at the public hearing, I don't think we should be trying to influence comments or prejudice for or against any particular topic, simply present them as the slate of things that have been brought to our attention, so that we have fair and open discussion. It's easy for these things to be able to be taken over by a small or loud minority, and we want to have good, open, honest discussion about all of them, I think. So keeping them just topic titles, I think makes a lot of sense. I just wanted to reinforce that.
But what we have in front of us is what we have asked the committees to submit, so I think we need to look at what's been submitted to us. Perhaps after all the vote, you can split in some committees, and this next 2 weeks you could reframe it into a topic. But I think right now we have to honor the language that was submitted to us.
Well, I don't see why. I mean, we're a committee of the whole now, reviewing what the subcommittees have done. I think that is our job exactly, to decide how to bring this stuff to the public hearing, quite
Okay.
honestly.
So you have a proposal? You'd like to present?
Well, I'm proposing as we go through these, we try to decide if they're in or out, if they're appropriate or not,
Okay.
and then try to phrase that as a topic title.
Okay.
I'll make a motion. In Article 1, I make a motion that 3 items are forwarded. The first item would be adding the word coordination rather than cooperation. Item number 2 would be adding a section talking about the rights of privacy. And number 3 would be adding, redefining the definition of scope for our charter.
Second.
Moved and seconded for adoption of the 3.
Who was the second?
Second was Rod.
Sorry, Trish.
Okay. The 3 points under Article 1 as submitted. Discussion? Okay, Ted?
Okay. I move to amend the motion to delete item 2 from the 3 that are going forward. The county charter adding the right of privacy and personal affairs is really not appropriate for this at all. Governed entirely by federal and state law, and we really have no need at all for it to be at the county level. And I think it's just a waste of our time.
I'll second that.
Okay, wait a minute, we have to make sure the maker of the motion accepts the amendment.
No, they made a motion.
Oh, no, it's not friendly.
It's not friendly.
You can make it friendly, that's fine with me.
Okay.
Okay, so is the maker of the motion willing to delete 2?
Yes.
No.
And the seconder is not willing to delete 2. I would say for the record, we'll move on, but we'll continue this, but I think makes life cleaner if you would just address a single topic at a time instead of trying to, because this is the kind of stuff we get into, so, okay. So the seconder of the motion is unwilling to accept that.
And you have a second on the motion to amend. Correct.
But you can't make another motion when we have a motion on the floor.
Well, you make a
Sure you
motion.
can.
Sure you can. Make a motion to amend, and that was what the motion was.
All right, so let's vote on that.
Well, do you want any discussion?
All right, what we have is we have the original motion on the floor to accept all 3 items under Article 1. Then they attempted, the maker said he would withdraw 2, but the seconder of the motion said he's unwilling to withdraw 2. So we now have another motion on the floor to amend the original motion, and that is to delete 2. Discussion.
Yeah, I'm in favor.
Okay.
I'm in favor of the motion, simply because I agree with Commissioner Miller that this, as important as this right of privacy and one's personal affairs is, it's more than adequately covered by state and federal laws, and it seems wasteful and redundant to include it in the charter.
Ron and then Don.
What I do, putting every one of the 10 Bill of Rights into each one of our charter amendments, does that make sense logically? I just don't think that it is necessary and belongs in the charter.
Okay, thank you. Don?
I'm just wondering if there's a simpler way to do this. Can I speak to that? Like, why don't we just have a raise of hands on yes or no on any of these things going on down? If there's a majority, we'll move it on. If there isn't, then we won't.
But that's another motion which
Okay,
can't
I'm just saying.
but I think it's a reasonable, rational way to do
waste
it.
of time.
Because we could have been to Article 4 by now, so we've
Exactly.
just done one article at a
So
time.
just get on with this. I don't have that.
Okay. So, hearing no other comments, the motion in front of you is to delete 2 out of the original motion. Those in favor of deletion of 2? We're voting to whether or not you want to delete number 2 out of Article 1. The maker of the motion is, okay, so you got 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay, so it's deleted. Thank you. So now the motion is left is section 1, changing cooperation and coordination, and 3 is changing section 1.30. Any further discussion? Okay. Nolan?
Yes, I'm wondering why he felt it necessary to abbreviate the wording for number 3. I thought it was fairly abbreviated as it was.
I'm trying to make each one line. That was my purpose behind it. I'm trying to make each one a line.
So right now we're doing concepts, remember? So the concept is to change section 130.
At some point, we will flesh it out.
Absolutely.
Yeah.
Okay.
Are you ready to vote on this motion? Current motion is Article 1, accepting number 1 and number 3 to move them to the public hearing. Those in favor? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Is that right? Okay, pass. Okay. I would like to go with Don's suggestion and say from now on, if we would just deal with one sentence at a time, we can get in and get out pretty quickly. If that's okay?
Sure, but point of order.
Yes,
Point
sir.
of order. I mean, the motion was really very specific in its phrasing, capturing each of these as title phrasing. Is that being recorded somewhere? Did somebody write that down?
I mean, I think Trish can probably
Okay,
do
okay,
that
just
for
check.
you.
Okay.
Norma, I think,
Yes.
excuse me,
Yes, sir.
I think all of these are essentially concepts. If we wordsmith this kind of stuff, it's not the time to do that. It's not going to be helpful. Each of these should be viewed as concepts that we can then bring and summarize to the public. And so to try to wordsmith in any of this kind of stuff is I think, not helpful. So I would still say yay or nay on these kind of concepts and move on.
I think you have a motion.
You already suggested the process. So
Okay.
I'm saying let's do
So,
that.
under Article 2, we have actually just 2 items.
Norma?
Yes, ma'am.
If we're going to do as he said, when are we going to do the fleshing out? I don't see a calendar window when that can be done.
We can come up with that. You'll remind us, I'm sure.
We will be developing our calendar. Nola says we will have pro and con arguments. The final
So this
argument.
isn't our hard and fast, it's variable then, our calendar.
This is sending things to a public hearing. The actual language that will go on the ballot will be very precise, and that will be done in June. Ron?
I don't have a problem with Don's suggestion at all. I think to move this along is perfect. But if something comes up that you don't understand, may we still ask a question about
I
that?
think absolutely.
Okay, that's
We
all.
have to be able to, we're supposed to talk, so.
Yes, just so long as we're not cut off on that, we're just yay and nay.
I appreciate that.
So to meet that, is it acceptable that on Article 2, what we propose for the public hearing is just a discussion about county commissioners, whether they should be elected by primary or general election, and how many should we have and how should they be, as outlined in 3.
I move to move
Those-
forward.
Okay. I want to, just for the record, note that people always say, oh, why should, people already voted on that, and that I looked it back today, and we have voted on 5 different occasions whether or not the election of commissioners should be by district in a total scale. So just for the
When was
record.
the last time?
I have those numbers in my thing. Anyway, all right, so somebody want to make that motion that we just have, or accept Article 2 to have the concepts of county commissioners electing by district and the number.
I guess my original intention was that Article 1, or Article 2, 1 would have a yea or nay, and being able to move on, because I think we are combining too many issues there.
Well, I need some motions.
I have a motion.
Yes, sir.
Let's accept, move Article 2, number 1, to a public hearing.
Second.
Let me, I can accept that, we can move on, but just to make life simpler, is it okay, instead of having this formal, I move and second discussion, if people just, should we just say, Article 2, number 1, should it go to public hearing, and we just raise our hands?
That's
And if
good.
someone really wants to have a discussion, then they'll say, wait, I want to make a point.
Good.
Does that sound reasonable?
That sounds reasonable.
Okay, so if you want to withdraw your motion, we'll do it that way.
You want to withdraw
The
your
maker of the motion one. Okay, so Article 2, number 1, which is the election of county commissioners by district in both the primary and general election. How many would like to see that go to public hearings? It goes, okay. Number 3, should the charter have 3 county commissioners or change to 5?
Two accept two.
2.
Oh, that would.
2 is not a public hearing, it's a request to,
That's going to be under other issues.
it's a request,
Okay, but that's what I was wondering.
it's a
'cause I
request to
don't-
Mark Nichols.
Yeah, I don't understand that either.
Yeah, with that, we'll come back to that, because that's not a public hearing issue.
Okay.
Okay. Number 3, should the county have 3 commissioners or change to 5 with all these miscellaneous configurations? Those who believe it should move? And we have 4, 5, 6, 7, we have enough, okay? Trish, do you want the exact number of votes? Nope. All right. Article 4, should the DCD director be in an appointed position, and the other is should the DCD director remain in an elected position? So I maybe only need one of those, because it's already like it's sort of redundant. So basically, Article 4, you just move number 1 forward. Correct? Okay. So, those in favor of moving to the public, should the DCD director be in an appointed position?
I'm sorry, what?
Okay, all right.
Whether or not
ready?
this,
Okay.
whether or not.
We're on Article 4.
Right.
Should the DCD director be in an appointed position as an article, is a concept to move to public hearing? So I'm calling for the hand raising. Okay, you ready? Okay. 1, 2, 3, 4, 5, 6. Okay. That fails. Okay. Article 6. Should the charter add a definition of the county to define it in a way that includes all elected officials under the home rule charter? Okay. It's a concept.
I don't understand it, so I'm going to ask for clarification from the committee.
This came out of the discussion with the administrator when the charter refers to the county. When he was asked, who is the county? He said it's the county, it's a majority of the county commissioners. So there is some question then, why do we have other elected officials if they aren't considered part of the county? Yes, sir, Steve.
I don't know if he's right. That's a question that should be answered to the prosecuting attorney. He may be wrong on it. I don't think we should forward stuff forward based on something that may not even be correct.
Okay.
I mean, I think that's what a prosecutor needs to ask. That's his personal definition of what he thinks it is, but it may not be the county's as a whole.
But how do we know? But how do we know unless it was defined in the charter?
Well, you gotta talk to the prosecuting attorney. Let him decide what it means.
Yeah, but that could change by any prosecuting attorney, I suppose. So you're always asking, who's the county today?
Ron?
As I recall, when the committee met on that, it's just the first 2 sentences of 6.20, whether the administrator shall serve the commissioners and the county. And does that "and the county" have any meaning, in the sense of meaning more than just the county commissioners? That was, I believe, what the rationale was behind the committee's thinking.
Ken and then Nolan?
Well, I think the real question here is the equality or parity among, I mean, in theory, I think all elected officials have equal standing is the question that was raised. And the way the charter reads currently is it puts all the emphasis on the county commissioners. And I don't know whether that's true by state or federal law or whatever other laws we're governed by, but that's the underlying issue. I mean, there's a concern about whether or not all the elected county officials have enough say, you know, by virtue of their being elected in the matters of the county that they're responsible for.
Maybe this number one is actually taken care of in the body of number two. Right.
Well, I guess, I'm not sure I rely upon the county administrator to give a legal opinion as to what the definition of the county is for the purposes of legal representation. I think I said that nicely.
I don't think we're asking for a legal opinion of the county.
What we're saying is the county administrator who told us who is and isn't part of the county. And I'm like, he's not the one that gets to decide that. I mean, if we're unsure who's represented, I would ask for a legal opinion.
So I'm going to call on these other two hands that are raised, and then you can have a couple options on this. Obviously, vote up, vote it down. And the third option would be to send the question to the prosecutor. So Linda.
I'll pass.
Okay, Mike.
So I think it's specifics of state statutes, what it represents the county. So real estate items is county commissioners, treasurer's O&M fund, it's the treasurer. Imaging fund, it's the auditor. So for different purposes, the legislature has mandated certain duties, independently elected officials to carry those out. And there is a tip in some courthouses about commissioners telling somebody to do something, like the auditor's historic duty with budgets. But overall, the state statute, the legislature defines the law for 39 counties, dictates who's the county for a specific purpose.
Any other comments? No.
I'm wondering if we couldn't just stop, and should the charter add a definition of the county, leave it at that, and then talk to our prosecuting attorney about this, that as all elected officials under the code, and find out from him if that would make a good definition. But I think that there needs to be a definition. We just may not have honed in on the words.
It sounds to me from this discussion that this is actually your preference is to clarify this with the prosecutor rather than send it to public hearing. Am I hearing right? Okay, so can I assume that that's, you want to officially vote it down or?
Until we hear from him.
No, I mean.
Put it under other issues, then.
Okay, so number one then, we'll move to,
The parking lot.
we'll move it to going to the prosecutor. Well, we'll have to address that officially later, actually vote on it.
Is there any reason why we can't do both, send it to the prosecutor and to the public hearing?
That's why I suggested that stopping the wording of the definition, that gives us both options.
All we're looking for is the definition.
All right, so then what I'm hearing is you want to amend number one, so it will read, should the charter add a definition of what is the county? And then that's what we would send to public hearing. All right, those in favor? 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay. Number 2 is long, and Ms. Van.
Don Orson had to leave and he
Okay.
left his voting things for
Oh.
each one. Do you want me to
Okay.
say that, or because you're kind of busy, you want me to?
Okay, yeah, actually, if he,
That's not legal. He's not here.
oh, okay,
Yeah, he shouldn't matter if he's not here.
okay.
There's no proxy.
No proxy, you can say, well, he is interested this way, it doesn't count on the vote.
He should have stuck around.
All right. 2, should the charter define the duties of administrator in the following language? And you have the specific language. Basically, as you'll notice, this is asking him to coordinate more with the other elected officials.
I'm not sure that this is the right language, but I do believe this should go forward to a public hearing so that we can get the give and take on the public on it.
So perhaps this language is too detailed. It's way too detailed to send for a public hearing. So this is one of those things, if you vote yes on that, you need to redefine the language just into a concept rather than what we have. Ken?
Yes, I don't disagree with what Commissioner Miller just said. I just wanted to point out what the intent here is. And that is to provide some separation of powers. We're the only form of government I'm aware of in the United States where the commissioners have full executive and full legislative authority, and I think therein lies a problem. I think certainly budget authority needs to be given to the professional in the organization, which is the county administrator, and to compel him to work equally with all elected officials and appointed department heads. So that was the intent, so the question should be, should some separation of executive and legislative authority be created in the charter?
So that kind of goes to Article 2, 3.
This is Article 6, number 2.
I know.
Okay.
But I said it refers to, those ones talk about legislative and executive separation.
Yep.
Okay, so, well, except that your global language for 2, is everybody hear what Ken said, what we're voting on for 2?
Yeah, I would definitely second the concept of the idea of legislative and executive.
Okay. Nola?
I think that that wording gives the administrator far too much responsibility, and I think that we shouldn't even move that forward at all.
Well, we're not moving this exact language, we're moving the concept. That's what Ken just proposed. So Ken, do you want to restate what
My concern is if it even reflects this at all, I oppose it.
Okay, you get a vote, you get a chance to vote no if you oppose. Ken, what, you want to frame how you want this to move forward?
I'd have to think about it for a minute here. I'm not prepared for this.
Well, if you have,
I mean, the paragraph, I think, makes it clear. Clear, but
I don't have a problem. I guess I'm the one that says, okay, it's written that way. Put it forward for a public hearing. It's not saying what we're putting on the ballot. Just put it forward for a public hearing.
No, all right,
The public can read. Let's presume they can understand it.
all right, okay. So we're going to rescind your suggestion, go with the language as written. Linda?
I don't like this language going forward either because it does reflect an increased authority to the administrator, and I think actually if you just get a definition of the county, that might actually solve the problems, some of the problems. At least I'd like to see what that then does to the rest of that paragraph, because the charter language where we're asking, where that definition of the county becomes applicable, that's sort of the rest of that paragraph. And I think we need to get that definition clarified, and then we'll see again whether there might be some more wordsmithing required. But at this point, this language is more rather than less, and that is definitely not something I can support.
Okay. So what I'm going to rule is that there are those who like this language and those who don't, and so that's what it's about, voting yes or no. So is there any other comment? Because what we'll do is vote to move Article 6, number 2, the language as proposed. So you can vote yes or no. Are those in favor of the language as proposed? 1, 2, 3, 4. Okay, so language as proposed doesn't do it. So hearing no other, number 3 was just.
wait a minute here, though. I thought we were trying to move concepts forward. I feel like what is essentially a good idea is being lost in the progress of this conversation.
Okay.
And I'm not willing to give this up yet.
All right, then.
Excuse me, is the concept then, should the charter define the duties of the administrators, and that's
The concept is to provide some separation of powers as they should be, specifically in the area of developing the budget. All department heads, elected and appointed, should have equal say in the personality of the current county administrator or any other county administrator. It's what county administrators do. They're the executive, and he doesn't have full executive authority that right now the commissioners do. And they can control the budgets of other departments based on personalities and all of that stuff. The truth is, the commissioners still have that authority, but I think we need to begin to think about separating executive and legislative authority.
Norma, may I?
Yes, ma'am, Glenn?
In the whole budget process, the administrator and the budget director meet with all the department heads and elected officials.
Right.
And they have asks, and they go through a whole process with that before they go before the Board of Commissioners again. So there's a process in place where all the department heads and elected officials meet with the administrator and the budget director already.
Find it.
Maybe I'm interpreting that wrong.
No, I mean, you're describing it accurately how it happens, with, they would like it to happen, but I personally, I no longer meet with the county administrator on budget issues because I believe that it does not at all represent what I say, or, it's not helpful, it's actually being used not in my favor. So I don't meet with the county administrator on budget issues anymore, so that's maybe why, this does not, I can understand what you're saying, when you have a professional that was more independent and has that, then that would work. But that's not what we got now, and that's sort of what I'm coming from, because, and I don't know what the answer is. I do think we need to look at, implementation and enforcement of what's already there, or an interpretation of what does that mean? How do we get what's already in the charter? From my perspective, I think the charter already reflects quite well what the county administrator should be doing. My concern is we're not getting that. But changing the language isn't going to get me there either.
Rod?
Well, I was going to suggest that maybe the concept is something like, should the charter define the duties of administrator in a manner that provides for clear guidance regarding the roles of the administrator with regard to other elected officials and with regard to the budgetary process. If that's actually what was trying to be said here, I think that was the goal and the objective, then maybe we make a motion with that concept be forward.
Do you
So
have
is
that?
that your motion,
Sure did.
Rod?
Also
Is there no motion on the floor?
I'll move.
Well,
Second.
Did you second,
Motion
Rod?
second.
No, I didn't.
All right, is there a second?
Connie did.
Connie did.
Connie seconded.
Okay, say again.
Okay, so would you restate your motion, Rod, and then we'll have
So the
a
motion
second?
is to forward the concept, or question of, should the charter define the duties of the administrator in a manner that provides for clear guidance regarding roles of the administrator with regard to other elected officials and the budgetary process.
I'll second that.
It's already seconded.
Connie did.
Okay, so Ron?
Because we had a vote on the other one that went
Right.
down.
Yeah.
So that simple is what you would propose that goes out to the county.
Correct.
Yeah.
Is that-
Okay. If you do,
Okay, Glenn?
I think you should also read number 3, because it's talking about the very same thing here. That it's everything different. It's suggesting that the county, they say move the county commissioner to a committee and the other elected officials to hear any complaints. Such this came from the degree added on. Such meetings should be arranged and reduced agreed upon structure held before July 15th. The result of these conferences might suggest changes in the emphasis of the administrator.
And that, Glenn, I don't think is inconsistent with what Ron's motion is.
No, but it gives a timeline and it gives a definite process under which this discussion will be held, not in the public arena. This just suggests that this needs to be addressed because it's an issue of controversy.
So you're saying that what 3 says is contrary to what Rod's motion is? Okay. You can vote that way. Yes, on the next page. Okay, so Linda?
I believe that the two are very complementary. On one hand, we can move something forward that some people consider personal to me. On the other hand, I think we have a legitimate issue of the duties of the county administrator and defining more in the charter. I think the two are actually quite complementary. Get the public's input and, and
So that's really what we're
provide
talking
for a
about.
process to hear me out.
We're just talking about, in some way, getting clarification of the administrator's role in the county government, aren't we?
Yeah.
Isn't that the topic that we can talk about?
That's what Ron's motion is.
Okay. That's what it says, that's good.
Ted and Ron?
Okay. Yeah, I guess my concern is, it doesn't matter whether 2 and 3 are inconsistent, we're just voting on whether to move it forward to a public hearing. They can be inconsistent. or even diametrically opposing it, still be legitimate to
Yeah.
move the vote forward.
That's right. That's right, exactly.
Ron?
Yeah, I just want to hear it one more time. I liked it, but I'd just like to hear the wording one more
And
time.
now she tests Trish to see how quick she types.
Well, no, I'm not trying to push,
Should the charter define the duties of the administrator in a manner that provides for clear guidance regarding roles with regard to other elected officials and the budget process?
that sounds really good. Good. Jeez.
Okay, are we ready for a vote on this one? Okay, those in favor?
Yeah, that was really good.
7, 8, 9, 10. Okay.
She's good.
Do you vote for your own motion? 11, 12. Okay. And then, so 3, I took as a comment rather than recommendations, but I guess you intended it as a recommendation, Glenn?
Well, I think that this motion we just passed does what we needed to do.
Okay. Okay.
I think that it should be moved forward to the Board of County Commissioners for them to consider acting on.
That we do later.
So that means we move number 3 down to other issues.
Yes.
Article section number 3, okay?
Okay.
We're up to 6 other issues, so.
Article 7 is sort of a housekeeping measure.
Yep.
Just simply, oh, Ted.
Yeah. It's really more of a technical correction. Right now, the state law and the county charter are inconsistent with each other, and that's never a good thing. This is really the Shuna Reeves technical correction amendment. The county charter refers to independent candidates which no longer exist under statutory. If you were an independent, that'd be a political party called the Independent Political Party. What they are is, what you do is you state no party preference if you're a true independent. And so we're just changing independent basically to states no party preference in the charter. And while it's a minor matter, really it's important that it be done.
It just doesn't sound very controversial, so if I have.
I have no problem with getting a hearing, a public hearing on this, but I would like to put it into other issues. And, because this is a housekeeping matter that, Riggs can forward through the commissioners to get this changed. She has a process to change the charter. We don't have to do that for her. She can do it herself if she feels so inclined.
No, I think it would really help if the charter review commission put its weight behind it. I would go along with sending it to the commissioners rather than to the ballot. But just in case there's some issue, I don't see any problem sending it forward to the public hearing.
Well, I would agree sort of with Steve that it's sort of non-controversial, it's cleaning up some language, and I don't know if you want to clutter your list of public hearings with a housekeeping measure. I mean, I don't have any opposition to the language, I just don't know that we can deal with it later, I don't know if it needs to go
Let
to
me make a
public hearing.
specialized motion.
Yeah.
I move that the charter review commission support the enactment of this, but we recommend that the county auditor forward it to the county commissioners for action rather than for us to do it.
Second.
Okay, moved and seconded that we request the county auditor to make this request directly to commissioners since they have the authority to put issues on the ballot and deal with it in that way. Is that clear? Is that what you, okay, those in favor?
Aye.
Unanimous? Okay. Was it unanimous? Sorry. You voted no? Okay, it wasn't unanimous, sorry. Article 8, in terms of initiatives and referendums, you want to deal with these, I guess you could deal with them separately, that's what we're doing.
That's what we're doing.
So, pardon?
I'm saying, stay consistent.
Yeah, Article 8, number 1, allowing initiative referendums to move the ballot process without transmission to the county commissioners.
Are we voting?
Well, we are unless you have a question.
Well, somebody needs to, before I can vote on this, somebody needs to explain it to me.
I'll explain it. Currently, right now, we're the only county that the initiative process goes through the commissioners.
What does that mean exactly?
It means that they have to put it on the ballot. The citizens can't send something directly to the ballot. Even though they get those amount of signatures, it still has to go through the commission and go to the ballot.
So you're saying that the commissioners can turn down people's initiative?
They're like a gatekeeper, yeah. I mean, they control that gate.
All right.
And so this is saying, there's a mini initiative that goes to the commissioners that they can work on, but we want to actually have a traditional initiative that bypasses the commissioners.
I understand that, I just wasn't, okay, that's fine.
Ron?
I thought the whole initiative process was to bring it to the people and not have to go through the commissioner. So you're saying the current home rule charter provides for that?
So those in favor of sending this issue to the public hearing? Is that one unanimous? Okay, it is. Number 2, should the county charter be changed to allow 120 days rather than 90 days to gather petition signatures for initiatives and referendums?
Isn't that rather a housekeeping issue?
Microphone, please. Housekeeping
Is
issue.
it a housekeeping issue, or is it something not debated by the public?
Well, it was just to align us with the majority of, the 120 is what most counties use. We're very short in our days.
Housekeeping.
So it could be housekeeping.
So I think
That's what I would say.
not a housekeeping.
Put it on other issues if you'd like.
Ron?
My question, just, you guys have checked the time, and 120 but still permitted to be on the ballot in a timely fashion. Okay, that's all.
This is one of those things that you could actually frame in your public hearing as initiative referendum issue doesn't transmit to the county commissioners, extend it to 120.
We probably all.
So you could put it all in one sentence if
Okay,
you wanted
good.
to. So Linda?
Steve, can I ask you to run this by Gal? Does this give her enough time? Did everything she has to do?
Well, since every other county auditor can do it, I would think she could.
Well, but not all the counties have the same.
Auditors always take care of the election.
Yes, they all have the same type timelines?
Yes, they all have. In fact, this is giving her more time,
Just
not
give
less
us
time.
time, so we'll give them.
Yeah.
I don't know what. Okay. I just wanted to double check.
Okay, Nolan?
I would like to see it moved forward just as, because I don't consider it housekeeping. That's a fairly significant change, even though it brings us into compliance with what others are doing. Being like everybody else is not necessarily the best thing.
Okay, those who want to see number 2 move to the public hearing, it could be combined with number 1. Those in favor? Okay. Fine. Article 10. This was language, as I understand, Rod, from your committee that you wrote in response to a request from Mark Nichols. Is that true?
I wasn't on the committee. It was Barb and Ron, as I understand. I wrote Mr. Nichols asked for something different. I wrote a response that tries to balance the current rights the employees enjoy, as well as addressing Mr. Nichols' thing, having done 21 years of personnel. So this attempts to reconcile both of those, and that's what I gave to the committee.
Okay, so I want to speak to this. Ron?
Well, I thought it was brilliant, in that it does say they can go through the current personnel policies, which they don't currently have the, well, it doesn't say in the charter that they have the right, but I'm sure they do. And then a right to a public hearing if they so choose, and they can waive confidentiality provisions. So I think it should be moved forward.
My question is, does this need to be in the charter, or is this a
It's
part of
in
personnel?
The charter's already got a
Yeah.
section like this.
Yeah,
I know, but you're just changing the language.
Yeah, what this does is basically says, you, the employee, have a choice, and you have to make a choice, not get 2 bites, which I believe is what Mark was trying to argue. The problem is the way Mark wanted it resolved was to say, we'll just put everything under the personnel procedures. The charter originally had this as an employee protection, would be my suspicion is the way it was created. So this keeps that right there, but it requires the employee to elect between the 2 options. And if they elect the one in the public hearing, confidentiality is waived for everybody involved. And so it's like, choose wisely. That's the choice you want to make.
Any other questions about Article 10?
Oh, yeah.
Those in favor of moving it to the public hearing? 1, 2, 3, 4, 5, 6, 7, 8. Okay. 11. Starting with the Charter Review Commission, should the charter be amended to start the term of office for the Charter Commission to begin January January 1 for a period of 1 year, with the first meeting being held within the first 2 weeks of January.
Yeah, let's move this one.
All right. Are you ready to move on this one? Okay, those in favor? Yeah, that was unanimous. Okay. Should the county charter provide that no elected county official, county administrator, or charter exempt employee as defined in section 10.20 may serve as a member of the Charter Review Commission? Steve?
No, I'm voting.
I have not called for the motion.
Oh,
I
sorry.
have not called for the hands. Is there any discussion about this? So Linda?
Yeah, I'm just sort of wondering, I'm feeling like persona non grata here right now. You know, from my perspective, I don't see any place else to go as a county elected official with any issues. I'm a nonpartisan person, so there's no party affiliation, not a union, I'm exempt. County administrator certainly doesn't work for me, nor does prosecutor. So I'm not allowed to be on the charter now, which is a specific right granted to county elected officials under state law. It's really, you're doing this very weighty job with a lot of fiduciary and statutory and constitutional duties and authorities and personal liabilities and this and that. And basically I'm told I'm not welcome anywhere. And that is a little disconcerting. So that's just my, that makes basic.
Madam Chair,
Yes.
this was not to be made personal at all. My concern in this issue is that when we're discussing issues that would affect the job of the elected person, that person needs to recuse themselves from any vote. And then if there's one recusal, and that makes it an even number, and we could end up in a tie. So I think it's doing the commission and the public a disservice to have a member of the commission have to recuse themselves.
My only comment is that I have no big argument, but I can just from personal experience, the charters I've served on have frequently had county employees, have had elected officials, and it frankly has never been a problem.
Yeah, I'm going to vote forward to send this forward to committee, but I strongly am sympathetic with Celinda's arguments. I'm not at all sure which way I'm going to vote on it, but I do believe we should send it forward to public hearing.
Okay. Any other comment?
So I feel the same way, and I've had some other things I could have added earlier on science, but I'll wait till after the public hearing. But for instance, here, I hope people would look at a few other alternatives. In the case, partially as the treasurer's mentioning, I, for instance, told my two colleagues I thought the Board of Commissioners should honor any independent elected official and have them come to a work session on the record if they wanted to make an appeal to elected county commissioners. My colleagues refused to do that. And so a number of issues sort of were underlying this general big issue. So I'm hoping people would look at other things, like at least giving access on a public meeting time for any elected official to come in and dialogue with the county commissioner.
Nothing prohibits that under this law.
It doesn't, except two commissioners can say, no, we're going to bury that story.
So, let's see, I lost my track. Where am I here?
We need a vote.
11-2.
I'm on 11-2. Okay, those in favor of moving Article 11, number 2, to the public hearing? 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay? Okay. Shall section 11.10.10 of the county charter be changed to elect the home rule charter every 4 years instead of the current 8? I went back and looked at the historical record, and what you're doing is staying true to form. Every charter wants to change the years. 1983, 1994, 2000. It's been on the ballot as to how often the charter review should be. So I just want you to know for the historical record that people keep revisiting this.
Madam Chair?
Yes.
Has the question been raised on 4 years?
Yep. There's 5, 5, 5, 10, 8.
So no 4.
But, you know,
Just-
I'm not trying to be funny, but
No.
we are in times that change so quickly that
and,
that's
you
why
know,
we put this on.
and in response to that, I keep reminding people that the Charter Review Commission is not the only mechanism to amend the charter. So if something comes up in 3 years or 4 years or 6 years, you can have citizens initiatives, you can petition the commissioners to put, and I mean, we are not the only act in town in terms of amending, but that's just my personal view. Okay.
Are we discussing a motion or?
No, we're discussing.
Okay, I thought, do we have a motion or we're discussing?
Well, we are looking at electing the home rule charter for every 4 years, and I'm just having
Okay.
a historical comment.
Move to vote.
Thank you.
I move to move this forward to public comment.
Okay. All right, those in favor? 5, 6, 7, 8, 9, 10. Okay?
Hey, Madam Chair, I have to, point of order, I mean, I thought what we were trying to do here is decide whether any of these items were charter amendment worthy to bring to the public hearing, and that all items would be. We've already eliminated one that was perfectly legitimate, and we just had a discussion on another one, whether or not it was worthy, not whether it was appropriate as a charter revision. That's what we're supposed to be winnowing, you know, things that are appropriate to be in the charter versus things that aren't. And I feel like we're having a debate over the value of things.
Sometimes it happens.
Well, let's get the ball.
The value is.
Well, I might as well go home.
Well, no, the value is
Right,
not
seriously?
the public hearing. So, number 4, should a new subsection be added? 11.10.40, Board of County Commissioner review of Charter Review Board recommendations. The language should read, the Board of County Commissioners shall conduct meetings as required, including district town hall meetings, to fully vet publicly all recommendations for changes or revisions to county operations and procedures not proposed for ballot measures, forward to them by the Charter Review Commission. The meeting shall engage the public and shall encourage public comment on the proposed changes and revisions. Upon the conclusion of the meetings, the Board of Commissioners shall issue written conclusions and response to the recommendations, including timetables for the adoption of the recommendation and/or reasons for not adopting the recommendation. So this is just a new section which gives the board some clear direction on how to handle charter review recommendations. Okay, Rod.
I'm voting no on this because while I would love to direct and control and suggest the way the commissioners should spend their time, I'm not sure this is going to help anybody in the concept of governance. I'm not sure this is going to help anybody in the concept of governance.
Okay. Glenn?
I just thought that this is what we're doing. We're engaging the public.
Microphone, please, Lynn.
Oh, this is what I thought we were doing, is engaging the public in proposed changes and revisions to the charter, is what we're doing right now. We don't need to set up another method of doing so.
This is a mechanism. We, as the charter, can, as we said, do 2 things. Put something on the ballot for the public to vote on, or we can have it under other and send it to the county commissioners recommending that they act on it. So this is language saying when the commissioners get the recommendation of the charter, this is how it should be handled. So it's not directing us. Celinda?
I really like the language in this, but I agree that, this is the implementation and enforcement issue is what I would come to. It's like this is beautiful language for the charter, and what do we do if they don't do it?
Well, the whole point is to not have the commissioners sweep these things that we spent a lot of time debating and discussing and deciding to recommend as for serious consideration by the commissioner, to not have them sweep it under the carpet. And what we can do by having something like this in there is call them on it if they do sweep it under the carpet. I mean, that's the whole point of the charter, is to have something to fall back on when the behavior is inappropriate by our elected officials or any other officials in the organization of the county, right?
But what would that calling them on it look like?
I have no idea.
That's okay. Ron and
Wait a
Glenn.
minute. I mean, it's the same as any citizen has a right to question the behavior of their government, and they can reference the charter and say, hey, look, you were supposed to conduct public meetings and discuss this in public. You need to do it, period.
So I think that's where we get to Article 12, subsection
No,
7 of 9.
Thing is, I'm not, I'm in favor of this, because I think it's a good idea, whether this is the right language, and I certainly agree with Rod, we don't want to overburden them, but on the other hand, we should compel them to be responsible.
I agree, actually, I agree with you. I agree. My frustration is with, I love this language, I'd love to see it in the charter. But my issue is, basically.
Maybe we'll have a grand jury to deal with
Okay,
it.
yeah, exactly. So, Ron and then Glenn, and then we'll try to do it.
Actually, what this is those items that we don't put out for vote
Right,
that get,
right,
that are covered by this section.
right.
And so,
I think
you would have to add a new section to the charter review.
Right.
That section there.
The public has a right to know how the commissioners stand on these things that we, as elected by the people, have recommended them consider. And so that's the point. The public should have the right to know how they feel about it. So when the next election cycle rolls around, they can decide whether they still like their elected officials.
Totally agree.
Glenn, you had your hand up.
Yeah, I just don't see how this, I think what we're doing here is what's stated here. That's what I think. I think we're engaging the public right now and getting the public comment on this, and we're going to suggest changes and revisions to the charter. To the charter, that's what we're here for. So I think we're accomplishing this thing right now as we proceed forward with this.
Okay,
Can I move for you vote on this?
all right. Those in favor?
Are we voting on
We're
suspending
voting
debate?
on Article 2, Section 4, Board of Commissioners behavior, how they treat our recommendations. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay, onward.
And we are, with that vote, we still do have the option of fleshing this out if the wording is not really comfortable with the concept, is what we're
Totally
voting.
reword it.
Okay, Article 12. Number 1, should all tax and fee increases and expected annual revenue exceeding $500,000 be approved by a vote of the people?
Call them up.
Call the question.
So somebody's calling for the vote, someone's calling for the question?
For the vote.
Okay. Okay, Ron, so, we have to have, we haven't had any discussion.
I just want, it's more of a question. What purpose is this designed to enhance county government? Has it come up as an issue recently? Why is it being proposed, I guess that's
It was brought by a citizen.
It's being to put a lid on spending is what it is.
Pay over, run forward.
Oh, yeah, I know.
But I think it's an appropriate thing for the public to discuss.
Oh, yeah, I just wanted to understand what it was.
I would like to know why the 500,000, what is the magic about that? Versus the million versus,
In fact, the last
just made
10
up a number.
in fact, in the last 10, I looked up in the budgets, and in the last 10 years, actually in the last 15 years, this would never, we could
Has
make
it
a number,
exceeded?
but we've never exceeded that, ever. So,
I think it was because
Yeah.
our county
because
administrator has.
it only comes down to sales tax, really, that this applies to. Everything else you gotta go to the voters and anyways. So, this is really, it sounds great, but I asked the administrator this language and said, how many times would this have happened? And they looked at it and they said, none.
Huh? Yeah, it's like, then you're saying to people, you're gonna get to do something that probably never gonna get to do. I mean, I have a problem with the language. But anyway, Ted,
Yeah, I also agree, the fact of the matter is, we're never gonna get a tax or fee increase of anywhere near this amount without it going to the people anyway. Why waste a ballot measure on this?
well, actually, they did. On the Harborough funding, as an example, specifically, the legislature allowed counties to adopt 1/10 of 1% if they wanted to, by a county commissioner, and there was a huge community effort around that, and they had standing room only, and they had 6 months of hearings, and in the end, the the county did adopt that instead of putting it on the ballot, and that raises about $1 million a year. And it goes to chemical Tennessee mental health, so that would be an example of that would have to have gone on the ballot, even though the legislature, the law allowed it not to be voted on. So there are incidents where this would. Okay, any other comments? Those in favor? 1, 2, 3, 4, 5, 6 fails. Thank you. Number 2, should any land use or environmental regulations and change to those existing costing in excess of $5 million as determined by a cost-benefit analysis be approved by a vote of the public? People. Again, I don't know why it's 5 million rather than 7 million or 10 million or 1 million.
Costing who? I mean,
and who does the cost benefit?
Does the
Who pays
analysis.
for it?
Yeah, I believe we have in our packet somewhere, and I don't have it handy, but Mr. Alberg wrote a letter to this commission explaining his reasoning behind these issues.
Right.
So I move that we take a vote.
Forward.
Okay, those in favor?
wait, are we voting or discussing still?
Well, I think we're voting.
Or are we voting?
Okay,
Still discussing.
we are voting. That was the intent of it. Do you want to vote on her
Okay,
motion?
no, that's fine. It just, there's confusion when it
There
said
is.
I move and there's a second.
Yes.
That means we should be voting on the motion,
Yes,
which is, we should vote.
we can do that. Okay,
Or we can just say, okay, at this point, I'm calling for a vote.
all right. Sue, do you want us to vote on your motion, or do you want us to just go directly to a vote?
Call for the
I
vote.
thought we decided not to have a motion on the vote.
Yeah, not
I know, but we have people still making
We haven't been
motions.
having motions.
Just call for the vote.
John just called for the vote. All right, Sue just calls for the vote. So, those in favor? 1, 2, 3, 4, 5, fails. 3, should county trust lands be returned to county control and management for the purpose of improving the economic contributions these lands provide to support employment, business, and government services? So, Glenn, do you want to address that?
Others.
Because is that under other, or is this a separate?
Well,
I'm a little confused.
it really needs to be under other issues.
Microphone, please.
I think it's
really
worth
needs
hearing.
to be under other issues. This is going to take a long time.
But isn't it worth hearing from the community about what they think about it?
Well, if you're,
The community is circulating.
go ahead.
Well, this is one of the things I'm fairly certain is policy and not appropriate for the charter. I just don't see how you fit this into the charter.
Well, that's what these,
I mean, commissioners can campaign on this kind of stuff, if that's what they want to do. I mean, I just don't see it. Somebody has to explain to me how it fits in the charter.
it's not recommended.
Yeah. I think there's different languages being proposed.
So, Ted, did you have your hand raised?
I was just going to make the same point as Ken. I tend to be sympathetic to this argument, but it should be a matter for the county commissioners to decide, not the charter review commission.
Okay, Connie?
And in fact, we do have a recommendation, it's under other issues for means to move this forward in a different way, without putting it on the ballot right now.
Here's what it
Okay.
says, if you want to hear what it says
Well, that's
in the recommendation.
Yeah, we have those recommendations.
It says,
Okay.
because of the complexity of this idea, the Charter Review Commission recommends that the county commissioners establish a county trust lands advisory committee within 3 months, composed of individuals with necessary expertise to address this issue of reconveyance, and continues work within 13 months. And this group will examine the following. So it is heading for the county commissioners.
So you want
It's
to,
not for a public.
That's what's up, I think 3, the committee didn't recommend 3 be put on, we recommended that instead of 3, we do this other thing, which is now on other issues.
so what I'm hearing is we take 3 and move it down to other issues.
Like
Under
Glenn said at the
enforcement.
start.
And then that may become one of those things of a discussion and recommendation to the commissioners.
Right.
Rather than that. Okay.
Is somebody keeping track of all
Yes.
those things we're moving?
Yes, ma'am.
Yes.
Yes.
Okay, thank you, because I lost.
I think there's at least 3 of us.
We got it.
Okay. 4, shall the charter be amended to provide for protection against imposed mandates? As proposed, this amendment would add language to section 12.45 as follows. Protect local control against imposed mandates, including the Board of County Commissioners shall adopt policies and ordinance that preempt state and federal land use and environmental mandates, require independently, rigorously verified scientific studies to validate the science and underlying environmental regulations that negatively impact property rights, and C, require the benefits and new environmental regulations outweigh the costs as validated by rigorous independent economic cost benefit analysis. A little more detail.
I mean, as much as we may like to have this, wouldn't this feel illegal? I mean, wouldn't we be in litigation for the rest of eternity? I mean, we could maybe ask the commissioners to take these issues to our legislators, but, sorry.
Yeah, no, I believe that the doctrine of federal preemption, and the lawyers in the room can correct me, applies to federal government preempting. I've never heard it being used where the state or county can preempt federal law.
We could secede from the union.
Well, that's true as well, but I mean, I'm just.
Someone who would like that.
Noah?
I guess I wasn't on this committee, so I don't know where their background is, but it seems to me that the charter is our local constitution, and it seems to me that that's what they're trying to do, is to get this local control in our local constitution, which is our charter. I think it's appropriate.
But,
Okay, Steve and then Ron.
well, I mean, our charter can say the sky is green, but that doesn't necessarily mean the sky is green. Law will dictate who gets to decide this, regardless of what our charter says. And so we could say this stuff, but the law is gonna decide whether we even have the authority or jurisdiction to do that.
But that doesn't preclude us from moving it to letting the the citizens decide that that is something that would be appropriate, then let the lawyers do their own thing, but at least we should start with the premise that this is what we want.
Yeah, you might give them a false hope in this process if you think.
Or we could fire all the lawyers.
So Ron, you're next.
I understand what I know that you're saying, but I thought that our direction under the Charter Review Commission was that the amendment that we put forward must be consistent with the U.S. Constitution and the laws of Washington State. And it's not my belief that where you're saying the local government preempts federal law is constitutional at all.
So I think we're ready to vote on this. Those in favor of moving 4 along to public hearing, raise your hand. And fails. Okay, 5, should the county charter add language to include compensation by the community for impacts to property owners for costs or damages suffered under regulations to further a social benefit?
Whoever wrote that, just explain what they're getting at here.
I have no idea.
No one's gonna press
So if we don't understand the language, those in favor of moving it along?
I think that it was a Kyle Bergen, and it had to do with the water rule.
Okay. Those in favor of moving it along? Failed. 6, should the county charter include the county commissioners and the director of Department of Community Development have an affirmative duty to protect the county's human environment and shall place the county's human environment on an equal footing with its natural environment. The county commissioners shall make state and federal authorities show cause before they pass regulations detrimental to the county's human environment.
Because the environment's the environment. It includes all of these things. I feel like we're creating definitions that we don't have any authority I'm opposed to it. I don't get it.
Ted?
Well, human environment is a subset of natural environment. You can't have human environment isolated from the natural environment. And this simply makes no sense.
When I first read this, I tried to Google human environment, it doesn't work. Because environment is environment. It's new language, it's not Googleable. Anyway, Connie?
Well, this was brought forward again by the public, and I think that the thought was that some of the natural environment, including fish, is way more heavily than human, and like with the water rule.
I think that it was brought forward too because of the feeling that the Department of Ecology was overstepping, and to try and give us more local authority to prevent that from happening. And again, it's because of that type of thing, the environmental issues, that were taking precedence over us as individuals. I think that's where it was coming from, was that reaction to the Department of Ecology.
Seeing no other hands, oh, Ken?
Well,
Careful, Ken, I'm here sitting.
I know. But it just seems like you're opening up a can of worms that you can't resolve. I mean, it's getting into a debate that, goes to a much higher level than we little folk here in the county. I mean, again, it's not about whether there's something desirable within this, it's just whether it's appropriate to. I just don't see how we can, I don't even know, there's nothing specific in here about that's actionable, I don't think. I mean, I don't know, maybe one of the attorneys can,
They're quiet.
No, they wanted to kill all the attorneys earlier, but now they want us to defend their action. That's always amusing to those of us with law degrees.
Seeing no other hands, go ahead, another comment? Can I just careful what you said?
I had one more, and I'm wondering if it couldn't be simplified by just saying that shall the county charter include that the county commissioners and the board and the director of the Department of Community Development make state and federal authorities show cause before they pass regulations. So it's the last part of that last sentence. I think that simplifies it and makes it a little bit more palatable.
Right, you still have human environment mixed in there.
Okay, so do we need to change that word?
I think,
based on what we've been discussing here and what the intent was?
well, what I like to know is just take it as it's written, and then if you want to come back and visit it with different language, we can do that.
I wasn't even on that, so I don't know, that just seems to me what they were trying to do.
Okay.
Yeah, I would like to hear what the public have to say about this, so I would move that they go forward.
You're just calling for the vote, is what you're doing?
No, I'm speaking in favor of it.
Oh, okay. But see, you said you moved, so I get, sorry, I have a motion. Ron gets on my case for having motions that I don't act on.
Well, he's dead now.
Yeah. Okay. All right, so I'm just gonna take that as a move to a vote.
Correct.
Those in favor? 1, 2, 3, 4, 5, 6. Fails. 7, I think you already decided 7 was going down to other.
Correct. So the 6 other things that I have, that on my notes I have, is 1, Forest Board trust land issues. 2, Clallam County grand jury issues. 3, proposal for charter enforcement commission. 4, election of commissioners by district and the Yakima voting case, a request of the prosecutor. 5, the definition of county, a request of the prosecutor. And 6 is Article 6.3, so I did shorthand, I just need to go back up. Oh, the issue of the meeting and the airing of complaints.
What about
So,
11?
Article 7, number 1, 2.
Okay, I missed one.
And 11, where you had number 4, where you were discussing about the Board of Commissioners.
Well, shut up. No, wait a sec. I have Article 7, number 1 passing, 13 to 1.
No, that was the DOCC.
No.
7 went to other issues.
Yeah, 7-1 went to other issues.
7-1 did.
Was a housekeeping.
Did you have it?
That is the one that we voted that Shuna Riggs should ask the commission.
Yeah, so we already dealt with it.
We dealt with it.
Yes.
Oh, I see what
We
you're saying.
pushed it on somebody else's desk.
Yes. Okay, and then what was the other one people had?
11, Article 11, where we had number 4, we were talking about the Board of Commissioners review the Charter Review Board recommendations. 11.10.40.
I think that was,
That was voted
Trish, that was.
This takes out language.
Well, the motion has
So
revised
vote
language.
Trish on 11, number 4.
Yeah, we changed it.
Was what?
Huh?
Pass with 10 votes.
10 votes.
Yeah, 10-4 is what I have.
Okay,
I've got it, I just wrote it down.
yeah, all right.
like I said, I only had 6.
Okay,
You're right then.
I have 5.
Even the dead can be right.
Okay, I'm going to get to Linda in just a second. I just want to clarify this list, Linda. So there are 3 issues as written: force, grand jury, charter enforcement. Then you added, Rod, referring to the prosecutor. So that I see as a separate
That's
discussion is
Number
referring
4.
to is the Yakima case and the definition of county.
And number 5 is the definition of county. I separated because they came out of the
Right.
thing above. And then number 6 is this.
I missed what 6
6 is, it's Article 6, number 3, and I say it's a means of airing complaints.
Article 6,
Yes.
number 3.
Right. It's on the last page.
That's right. So we're moving that to
Other issues.
other, with the possibility it's going to be a recommendation to the commission, correct? Okay.
Kind of thought process.
All right. So Linda, you're next.
I would like to, I don't believe that the vote was for Article 7, number 1, was the vote to keep it off the ballot and pass it back to Sheena? I mean, just because, where people could propose this one, directly to the commissioners too, I think it's still an important request. It came to us, and I believe it should still be on the ballot. I think it was just not going to the public hearing because it was, with the public hearing going to weigh in on a technical issue. But I think we should still keep it on the ballot, or at least keep it on the list for things to vote on later, whether we should put it on the ballot.
Article 7, number 1, that's the one where it states no party preference.
Right.
Yeah, there was a motion by Miller
Yeah, it
and to forward it to the board for action, and Plex seconded, and the motion carried.
was basically
That's what I thought.
housekeeping.
And one of the ways you can handle that, is you could, when we, at some point in the near future, you could make that recommendation to the commissioners, giving them a deadline as to when they might put on the ballot. They ought not to, you can come back and the commission can put it on the ballot. So there are ways, we've done that before.
I have a question.
Does that need to go on there?
Rod, have we talked to the county prosecutor of the concept of the reconveyance at all? Has he looked at that, or do we need to forward a
We have, and under the other issues, under number 1, if that's where we're at now, the committee has a recommendation on that issue that probably would be worth considering by this commission.
Yeah, and normally we would do a stand-up break, but since you have to leave at 8:30, I'd like to suggest if it's with everyone's permission, we'll
And then I'm
move.
gonna call, the idea is I'm calling the minute I walk out the door.
Okay, we will move directly into the Forest Board Trust issue, and after we've discussed that, we'll have a break. Does that sound okay?
Can we get the minutes done at some point here?
Yes.
shortly?
Oh, get those. All right, let's
I
take.
move approval of the minutes.
Second.
All in favor?
He's pretty noisy for being dead.
Connie, call us back to order. Who moved to approve the minutes? Is that Rod?
Rod.
And
Connie seconded.
Connie seconded. Is there any addition, correction, discussion?
No.
Hearing none. Those in favor of adoption of the minutes as stated in our packet. Actually, maybe it came out not this time, the last time?
It's part of your agenda.
Yeah,
Yeah, part of it came earlier.
okay, yeah.
Day before 6 came earlier.
All right, so go for it, Glenn.
Okay, this really, after discussing this and the complexities of this discussion, there's no question about this. There's no question that this has to be carefully considered, and
more than one setting, because it's a very good idea, we think, because we think there are some savings that could be made, substantial savings in managing timber, and in affording more opportunities for us to be considered more about our local employment. And we've even had a little bit of estimates. I don't want to give them to you because I haven't had an opportunity to check with the person that produced it, but he's a very qualified person, and it's substantial. I can only say that at this moment. We know with the Grays Harbor example, it's staring right at us. I called and talked to the forester there for a long time. He doesn't want to be involved in this at all. He already has been on one other occasion in 1996 when this came forward. And it took up all those times. He has no time left to run the forest. But it's a small, it's a 40,000 acre forest is what they're managing there, and they have for many, many years. I asked him, I said, well, how did you get this thing and nobody else did in the whole state? And he said, we don't know. We actually really don't know how we ended up with it. That's what he told me. Not just once, but several times. They couldn't track it exactly how it happened, but they do it. And so anyway, if you read this suggestion is that we think it needs to go to some committee to discuss it and look at all the ramifications of it, the legality of it, and find out whether it has any, if it's going to fly. Yes.
You know, I think it's a great idea to have local control over the resources, but I guess I feel like what's being asked, I mean, I don't see how this fits in the charter, and I feel like let me finish, please. I feel like what we're trying to do is to simply make this change, you know, to return control of the forest lands to the county, which is a one-time action, and I don't see how that is appropriate within the charter. I guess I mean, where would it go in the charter, and what would the charter
Well, he has a
section
couple of
title be?
recommendations.
I think Ron could answer that very well.
Well, I think the recommendation from the committee is that the county commissioners be asked to form within 3 months of receipt of the recommendation a citizens advisory board on the issue of trust lands.
Yep.
And that advisory board then has nothing to do with the charter. We can make recommendations to the commissioners.
So that's what we're considering.
And that's what we're considering, is a recommendation to the
Okay.
commissioners that they form this committee, that it be conveyed to certain individuals. They look at the issue. Is this in the best interest of the county based upon, I don't have the language in front of the bunch, but, you know, on the pros, the cons, the benefits, the challenges, one of which is legislative.
Budget incomes.
And that if they decide that it's not in the best interest of the county to seek reconveyance, make some series of recommendations as to how the county and/or elected officials can be more aware of what the Department of Natural Resources is doing, the revenue source of the county.
If you had an opportunity to listen to Rod's discussion of the arrearage that has occurred already with this administration,
I've heard it a couple times.
you would understand how much it affects this county. It's already affected this county. And so we have, just as you pointed out, there are 2 ways to go with this. We either suggest that we're going to go through a reconveyance process, or we're going to task the department in a way which is the county can follow on a regular basis, so that it doesn't all have to happen in force.
We've heard testimony tonight from the public on this same topic, and at least on 2 other occasions that I'm aware of. That doesn't mean that it's a preponderance of interest, but I think that it obviously is something that is of a concern. And having the commissioners look at it, I think, is a perfectly healthy thing. I don't see it fitting in the charter, but there are 2 articles here that are referenced where it may fit, and it certainly wouldn't hurt for us to look at those 2 sections and see if it would.
Excuse me.
The article is 4.25, and the other suggestion was 2.23.10.
That's okay. I'm not hearing what's actually being proposed.
This is what's being proposed.
Okay, well, I don't have a copy of this.
Glenn, I want to ask about, your committee is working you sent all kinds of information. So what, I'm curious to know what you see as the timeline. It sounds like you want to just go ahead, correct me if I'm wrong, and make this recommendation to county commissioners. They start working on setting up the committee, and that basically then removes it from a charter discussion.
That's right, exactly.
So you're ready to move that to the county commissioners?
That's right.
Sooner rather than later.
But he did set a time frame so that they wouldn't sit on it forever.
My
So I
time
thought
frame.
that we started the
commissioners on
discussion.
Excuse me, not at one at a time, please. Mike?
So I thought where we started the discussion at this point on the agenda was that we had 6 or 7 items that would be in the letter of transmission recommendations to the Board of Commissioners. That's when this would be discussed and included. Otherwise, are we going to go into each of these and any others tonight? I would say when we come to that letter, then we discuss each of those issues, and this would be one of them.
I make a motion to adopt the committee's recommendation to the county commissioners.
Second. Okay, so you are moving, Rod, to adopt,
The committee's recommendation, which is the request about the committee. So here's the
Dated 4/27.
Dave Ford, right here. Let me read it, since we seem to have 40 different
I
versions of
have it
paper.
somewhere in here.
427.
Yeah, I have it somewhere. That's why I did the synopsis, it's so
Yeah,
hard to plow through all this paper.
It's at the bottom part of that.
Yeah, it says, the Charter Review Commission recommends that the county commissioners establish a county trust lands advisory committee within 3 months, composed of individuals with the necessary expertise to make recommendations addressing the issue of reconveyance, and complete its work within 13 months from its establishment date. This group will examine the following: 1, the history, issue, benefits, challenges, and advantages of reconveyance of county lands to Clallam County, and if found to be in the best interest, to recommend such action as may be required to effect this change in the management of these properties. 2, if not in the greatest interest of the county to seek reconveyance, the committee should be tasked to provide guidance to ensure a continual engagement with the Department of Natural Resources on how it is promptly and adequately fulfilling its trust land objectives of Clallam County, its taxing districts, and its citizens. That's the recommendation.
Okay. Discussion, Ron?
Well, I just would say, the first speaker tonight talked about the length of time, if it was included in the charter, that this thing could last for a decade. So I think this is a much better procedure, just to directly send it to the, with some timelines.
Steve?
Just to answer Nola, just to answer your question, the reason that this committee that I was part of decided to do it this way is because there's probably going to need some legislative work at the state level for this to actually transpire. And so it's probably not the most appropriate place to put it into the charter, because it's gonna need some legislative work as well.
So I just want to ask the maker of the motion, Rod, the timeline for this to happen?
Well, if we pass this tonight, what I would suggest is this is approved tonight by the commission, that it says, recommends the county commissioners. So then we just send them a note saying, in our discussion on this date, the charter commission has forwarded this to you for your consideration. And it has a 3-month. The beauty of the 3 months is, we're still in office.
Yes. Well, and this coincides with what we talked about on your reconveyance, and that's why we put that time frame in there.
Because they're gonna have to go legislative. They're gonna try to do this. They're gonna have to start creating a legislative process to get the authority to get the lands reconveyed to them. And I think once folks realize that the intensity of what's involved with that, they're gonna find out that there may be some other options to put more accountability over the DNR through the existing process, would be my suspicion.
Okay.
Basically, we're recommending that this go before the commissioners
To the
for
commissioners.
consideration. I don't think all the details necessary other than pass along that.
Are there any other points of clarification or question before we vote on the motion? Mike?
So, for decades, boards of county commissioners have discussed this, and there's a group of, I believe there's 21 counties, timber counties, within the Association of Counties, and they, at times, will discuss this. And I was part of those discussions for years. So it is very complex, and it's something I think the community should have a dialogue on, because there are some very serious budget impacts when you do this. There's things like thousands of seed stock that you look at for elevation, species of timber. There's, as I recall, somebody can correct me, I think the wildfire budget last season was 4 times what they budgeted. With climate change, there's going to be a lot of wildfire risk. If you looked at the NASA paid-for study of our interface area on the peninsula and out on the west end. It's a very serious budget impact. There are things like that are involved in this issue. So my preference would be that we ask the commissioners to have maybe public forums and ask DNR and member companies to participate. But so far, in a relatively small group of folks have generated this in this form. The subcommittee was, I think, a 4-to-1 vote. It was pretty simple, move it ahead. There's very little on the downside being discussed. And it's a big, big issue. And if you had one major wildfire, Clallam County could be broke. They will contract with DNR for fire prevention, fire reaction. But it's a big issue, so I think you have to look at that. And I think I would agree with Rob that there are some intermediary steps. But behind this, the thing that bothers me the most, there is a movement nationally to take away public lands and sell them. If you look at it, there's a Senate bill right now that passed in the committee the other day, and there's an appropriation coming along with it to give money to states and local governments to figure out some systems to put public lands up for sale. Personally, I value parks, forests, boat launches, a lot of things, and they're involved in DNR. They're publicly owned. They're part of the commonwealth. And I think you should be hesitant to give that up when to date, there's only, in my career as county commissioner, only one timber company was eager to take over the management for the company, for the county's timberland. So unless there's a large public discussion, I'm not going to vote for it because it's a very sensitive matter. There's a lot of money at stake. And there are intermediate steps that could be taken with DNR in a community open discussion.
This might get us there.
Well, I mean, I guess my thing is we're asking the county commissioners to create a citizen advisory board. That's an open to the public board. I'd vote on the question.
I just asked one clarifying question in your, are we asking also the commissioners to make sure that all other entities that are involved, i.e. school districts, are involved in the discussion?
Right, the commissioners don't do that right now. I mean, I'm sorry, the Board of County Commissioners don't go out and talk to each junior taxing district. They've failed miserably in that regard and have for more than 2 decades. I think the issue is you pull together a county trust lands committee and you ask the trust lands committee to go out and say, what are the issues associated with this? Now, I think some of those folks would be wise to go and talk to some of the junior taxing districts who have not had anybody advocate for them, except some small little city that doesn't get any funding for the litigation, the time spent on this matter, with the largest recipient being the county commissioners. But that's just my personal opinion.
Go Forks.
Okay, I think we've had a lot of discussion on this, and unless there's other comments, I think we're ready to decide, or unless there's other questions that need to be clarified. Sue?
I move to call for the vote.
Oh, please don't.
Let's just vote. Let's just vote.
Okay, now we need 2/3.
Two-thirds,
So,
there's a second.
those who want to vote to cut off debate, move to, raise your hand.
This is just a cutoff debate.
Cut off
Just to
debate.
cut off debate.
Yep, now to vote.
Okay. Now, we have the motion on the floor. Those in favor? 1, 2, 3, 4, 5, 6, 7, 8. Okay? Huh?
9.
Raise your hand. I missed one, I guess. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9. Okay.
Okay, I do have to run, so I'll call in here momentarily when Trish gives me the numbers. I run out the door. I will say for the Yakima voting case, folks, I'll try to read a section out of the Yakima Herald as I run out the door, okay? I don't want to try to read this while I'm driving. I love the sheriff.
Well, let me ask a question, Rod. Do we really have to address that tonight, or can we put that off to the next
I
meeting?
think you need to ask the county prosecutor to look into the voting rights case.
I am not objecting to.
I think if you do it tonight, though, that gives them 2 extra weeks. If you wait till the next meeting, you lose 2 weeks. And I have this belief that Mark and them are busy, but I could be wrong.
Okay, can I ask a question?
Yeah, and then we're going for a break.
I know, because I want to break badly, but is it election by district for commissioners, and then is 5 the Yakima case?
No.
Or
Or
are
is the
they-
Yakima case, which deals with and look at the issue of the Yakima case in relationship to the election of commissioners. Because in a summary judgment issued Friday afternoon, the judge said The ACLU's case was strong enough to vacate a trial, and she moved directly there. What they did is the ruling determined that Yakima's current election system violates Section 2 of the Federal Voting Rights Act. In the final analysis, there's only one rationale, that the non-Latino voting could not suffocates the voting preference in the Latino community. Yakima currently elects council members under a hybrid system of at-large and district voting, a system which has been in place since 1976. 4 of the council members are located in districts by the primary, but all 7 seats are voted on at large at the general election. So they're elected by district in the primary, and then they're voted across the whole jurisdiction in the general. That sounds really familiar to me.
Yeah, okay, so those are together.
Correct. We're asking the prosecutor to look at the law.
We're taking a 7-minute stand-up break.
But if you can,
Well, we all do.
I did some research, and I looked at their examples, all of the ones that I've seen are state.
Issues go out to public hearing. So, there are the other issues on our synopsis here. What is the wish of the commission? Do you want to address those in a simple measure of should it go out for a public hearing, or what do you want to do? The forest trust land has already been taken care of in terms of a recommendation.
Well,
Yes, Ken.
Let me clarify, I mean, I thought other issues were still up for general debate, but then I sort of got slapped down for not seeing the obvious that the first issue was to be forwarded to recommendation. So then I got the impression that the other issues were to be considered as recommendations. So are we still having a general debate on these, or are these being considered for recommendations to the commissioners?
Oh, no, we're not. I want to say it's a little unusual. We have voted to send this forest trust land to the commissioners.
As a
But that-
recommendation to consider what's...
For the commissioners to do X and Y that's in the outline. Most charter review commissions go along, have their public hearings, come back and make a definitive decision about what's going on the ballot and exactly what that language will look like. And then anything that falls off of that plate, i.e. not going on the ballot, usually then is discussed. Do you just leave it alone, or do you create a recommendation to the commissioners? So this is a little bit out of the normal sync to send a recommendation to the commissioner in the middle of all that we're doing. So the commissioners voted to do that, so we can do it. But I would encourage us, I mean, how do you know what you want to send to the commissioners until you've made a definitive decision about what you're going to put on the ballot?
So to answer my question, these other issues are just things that needed more discussion before we decided if they were worthy of a public hearing. That's all I want to know.
And part of the problem is that things like the Clallam County Grand Jury and the proposal for Charter Enforcement Commissioner ideas that have been floating around, there has been no subcommittee that has actually had an in-depth substantive review of those. So that's why I'm not sure what you want us to do with these other issues. So, Steve.
Well, I think I would like to go with where Rod was heading before he left, was we really need to decide in these other issues what items we want to forward to the county prosecutor to do some research. And the more time we give him, the better. And I think there's some of these other issues that can be dealt with tonight just by forwarding them, if we get a majority vote, to the county prosecutor to look at and say, is there anything there that you know, is this in our scope or not in our scope? Is this legal or not legal? Is this, you know, enforceable or not enforceable?
I'm a little bit confused. I thought we really have only 2 that we're considering sending to the prosecutor. What is the question around the Yakima case?
We have the county, the definition of the county.
Definition of the county.
That we could add them to look at the county grand jury.
Why would we do that unless we have a definitive proposal?
To see what exactly, I'm not saying we have to, but I'm saying these are the ones we can, and if we're going to, we need to do it sooner than later so they have the time to be able to research it. And the other one is the Charter Enforcement Commission, and there is a proposal out there that he could look at to say, is this enforceable or not?
Except it really has not been discussed.
Well, I think that's what we
Yeah,
can do.
I guess what I feel like we've done all this stuff. We have another meeting between now and when we go to the public hearings. I personally would be more comfortable if the next meeting we have between now and then have committees that are willing to look at the issues of the grand jury and the Charter Enforcement Commission and get some clarification of what we're going to ask for in the Yakima case and whatever about defining the county and Article 6, number 3. Well, I think that's a recommendation to go to the commissioners, so it doesn't need to go right now, I think. Does it?
Pardon?
So I'm just thinking some of these things, perhaps we don't need to rush to decision tonight because we really don't have substantive information in our pocket we have a proposal that citizens have given us on the grand jury, but I have a lot of questions about it. And I would want, so I would hope that maybe we have people that be willing to meet between now and the next meeting that would do some more discussion of those things. So Nola, and then Ron, do you have your hand up?
Yes.
All right, Nola.
I had 2 points that I thought should go to the prosecutors. One of them was the definition of the county in 6.1.
Right.
And the other one I thought might be worth sending to them was something that we had crossed off our list of considering, and I think part of the reason we did was because we weren't sure of the defining of it. And that was in 12.2. So how would the county, my question for the commission, for the prosecutor, would be how can the county transfer lands to be returned to county control? How can that be done?
Except that is already, we've already voted to send that to the county commissioners, and it's now for them to convene the task force and raise those questions, and they have the county prosecutor at their table. So I don't think that we need, personally, I don't think we need to send any questions at all to the prosecutor, because he will probably be involved at the table when the commissioners.
Well, I know he said he wants these things ahead of time.
Well,
so
it's no longer on our plate, because we just voted to send it to the
the
commissioners.
definition of the county was still on our plate.
The definition of county is still on our plate.
So I think that's one thing we can cross off if we just say we're going to send that to him.
Have we moved to forward what Rod was saying about that Yakima decision to the county?
We have not, because some of us still, Ron, you talk so fast on your way out, some of us got a little lost.
Okay, what I would suggest, because our rules say in order for a county prosecutor to be asked to render a memo, the majority of us have to put a question to them.
Correct.
And under that set of rules, then our committee suggested that the county prosecutor be asked to review the Yakima voting rights case and the decision in the summer of 2014 as it relates to our current system of county elections, elections for commissioners, and whether or not that system we utilize is somehow impacted by that case.
But that case was not exactly what we have. That was 3 districts plus 2 at large, and we don't have any at larges.
No, but we do elect by primary by district and across those people then run across the jurisdiction. And that was one of the key factors in that case.
So, do you need to specifically refer to the Yakima voting case, or are you just want to ask, is it legal for us to be voting at the primary, at the district level, and at the general level across the district?
I think one option you could say it's legal because it's never been challenged and made illegal. The question is whether or not the case law on the Voting Rights Act
by that basic question, right?
I would word the question different, being an attorney talking to one other attorney. However, I just think the prosecutor needs to be called in on it.
Is there, okay, excuse me, we have a couple attorneys raising their hands, so Ted?
Yeah, I'd just like to point out that in terms of the issue of making it 3 districts elected strictly by district, the Yakima case is almost irrelevant. The Yakima case might make it more likely that we have to go that route, although I don't think so. But it certainly doesn't impair our discretion of going that route. The only issue is if we thought we had an ethnic problem or something, we might use the Yakima case as a basis for going the individual districts despite our preference not to. But if our preference is to do so, the Yakima case is irrelevant. We can certainly do that. If anything, the Yakima case would try to mandate us going to a single district.
Ken, did you have a question?
Rod, I have a question.
Ron, other attorney heard from?
Yeah,
Okay.
Rod, is that just at the Superior Court level, just what, that Yakima?
It's a federal court decision.
Okay, that's what I want to know. Okay, so it's actually for the federal court and not the Yakima County Superior Court.
No, it's a federal court. I don't believe it was appealed to the ninth, but I'm not sure yet. I didn't get a chance to check that.
Should we check that before we ask the question?
Well, there's nothing to ask the county prosecutor. I mean, that's his job.
I have no problem with that. I just wanted to know what the status was.
Ron, is that a motion?
So what is the basic question that I'm still trying to define our basic
The
question?
question is, to the county prosecutor, is to review the Yakima voting rights case, and it's fully in relationship to the manner in which we currently elect county commissioners, and provide us any guidance or preference as to whether or not there are reasons to be concerned about the current way we do elections.
I guess I continue to be a little bit confused why it's so important that we mention the Yakima case and not just asking the
Because
generic
it's
question.
the one that just decided that this hybrid system of voting, they violated the Voting Rights Act.
I know, but won't he find that out if we just have a generic question? Is our current system correct?
I
Send it to him.
All right.
Send it to him. Who cares what?
I'm asking, well, it's important we frame it. I'm just,
I would frame my question specifically, but I mean, if the others want to make a more general question, I believe there's someone from Mr. Nichols' office in there who will definitely understand what the intent of the origins and the intent of the origins of the question arise from.
in the midst of this discussion, I'm going to ask if the prosecutor would like to come up and make a comment.
Good evening.
Evening.
For the record, my name is Brian Wendt, Deputy Prosecuting
We
Attorney.
can't hear you, Rod can't hear you.
I'm sorry. Good evening. For the record, my name is Brian Wendt, Deputy Prosecuting Attorney. If the question is, without the specific citation to the case, I do believe that the Prosecuting Attorney's Office will be able to locate any decision from is it the Eastern District? Okay, we'll be able to locate the decision. And it sounds to me that the question being considered is whether or not the issue and the holding in that specific case poses any concerns for our own system here in Clallam County. And the Prosecuting Attorney's Office can summarize that issue, that holding, that reasoning for all of your edification, and then make maybe list certain concerns for this body to consider. I think it's relatively specific for our purposes upstairs.
Okay, thank you. So I'm looking for a motion, or you want to make a comment, Ken, before we get the motion on the floor?
I think we're obfuscating. The question here is, can we legally consider electing our commissioners by district? Isn't that the
That's
question?
what I thought we were asking, but
So we gotta make sure we
somehow,
find that out. I don't really care about the other case. I just want to know if we can legally do that, because that's the issue that's been raised.
that's what I was asking.
Today
It's
we
going to be
can't.
a very generic question. Say, Sue and then Ted.
I move that we move this question forward to the prosecuting attorney.
Second.
But you said this
Which
question,
question?
please tell me what the
Whatever
question is.
question he just said, he
No, I need
understands
to
it.
know in a motion, I need to know what the
The
question
committee,
is.
the committee request that Attorney Mark Nichols review the Yakima voting cases to determine its effects on Section 220.
Perfect. There you go.
We got a second.
Yeah.
It's moved and it's seconded. Any further discussion? Ted?
Yeah, I'm opposed to the motion for the simple reason that the Yakima case is utterly irrelevant to our issue. The issue is, can we go to a single-member district, whether for both primary and general election? The Yakima case, if anything, would mandate it. If it's not irrelevant, then we can certainly do it on a discretionary basis. It's something that would be interesting, but I don't see where it's germane. Why waste the prosecuting attorney's time?
And I would just state, I think we just need to have a real basic, simple question. The question is our current system legal? That's what we need to ask. And if the prosecutor finds the Yakima case is relevant, so be it. I feel no need to, anyway. I've talked enough. Any other questions? Call for the question, huh?
Reread the motion.
Well, the motion is as submitted in your synopsis here. The committee requests that Attorney Mark Nichols review the Yakima voting case to determine its effects on Section 2.21. Okay? Those in favor? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. All right. Got it. So while you're up at the podium, the other item we had on having the prosecutor use a moment for us is the definition of the county.
It's on the administrator.
Article 6. We are interested, and so someone want to move that question?
I'll move.
Okay, what's the question?
Ask the prosecutor to define the phrase "the county" as it occurs in Article 6.
Okay, is there a second?
Second. I second, but
Seconded by who, Rod or Ron or Ron? Okay.
wrong. Just a friendly amendment, might be definition of the county found in the second line, whether the administrator shall be directly responsible to the commissioners, and he or she shall serve the commissioners and the county, because that's the context in which this, in which we're asking for a definition of a county.
Correct.
Is that a friendly amendment acceptable?
Okay. Accepted. Okay.
And
Any
since
other
I seconded it,
Okay.
And that's the last sentence, right? The last sentence of 621.
Well, yeah, I see where you're coming from. It would be the same situation. County in both places.
Any further discussion? Those in favor of sending the question to the prosecutor? Looks like it's unanimous. Did you vote yes, Rod?
Yep, yeah.
All right. Thank you.
And I'm gonna probably have to drop off because the reception will die here in about 3 minutes.
All right. So, then I would like to propose to the commission that the issues of the grand jury and the charter enforcement commission are big, complex, and have little discussion, and I think with the lateness of the hour, we're not going to be able to do it justice. So I would encourage us to look at forming a couple of committees to look at those things and come back and report at the next meeting. Does that sound one way to treat other issues? Ron's gone. I will. So does that sound acceptable? So I need to know 5 people who would like to be on the grand jury discussion and 5 people who would like to be on the proposal for the Charter Enforcement Commission.
And if we have people who have already formed their opinion, can we have a balance on those 5 people?
I'm looking for 5 people that are willing to serve. And if I get 7 or 8, then we'll.
And which one are you doing first?
All right, county grand jury. Rondell. Let's see if I've got 1, 2, 3, 4. So anybody else? Glenn? And Linda? Did you want to be on that one?
Who will chair that and call us together?
I'm going to let you guys decide that. Ron Bell, Glenn, Celinda. Who are the others? Connie. And Nola. Okay, so afterwards, if you guys can figure out who you want to be. Okay.
What will be the objective of the committee? What should we expect? What are the deliverables?
It's up to you.
Well, I don't want to get the same stuff back, because the stuff we have right now doesn't, really tell me anything that I feel like I can take action on.
I would
And I don't
hope,
want to have the same information just that.
I would hope that the committee would look at other grand jury situations. I do know that California's had civil grand juries at every county level for many years, and know a little bit about how those run. How it has run and out. Because this one is sort of a mix that we're getting. So I would hope that if you're going to come back, you'd give us some background on where their grand juries and what their roles are, how they get chosen, what their mandate is, how it functions. Because this is one proposal, it doesn't mean that's the only proposal.
Could we suggest that those committees meet right after this to get their act together?
To get your chairman, yes.
Yeah.
Oh, you just became chairman.
No, no.
Okay, so who would like to serve on the Charter Enforcement Commission Committee? Barb? Okay, and Linda, you're already on this other one, so I'm gonna let you, you only get to if there's room. Okay, Steve? Let's see, 1, 2, 3, 4, 5, 6.
You can do 6.
No.
Inclusive.
Steve, Maggie, Sue, and Mike. Okay, so, So I prefer just to have, since it's okay, just to have you on one committee. Okay. So that one is Barb, Steve, Ted, Maggie, Sue, and Mike. So that's a committee of 6. You guys can decide who your chair is, and the other's a committee of 5. Okay. I wanted to, so basically we've sort of, we were going to create some other committees. I don't know that we really need to, unless there's a compelling desire. The articles committees have met, and you have the thing, we know what's going to the public hearing.
Did we address number 6 under
Number
others?
6.3, no, we did not.
What is?
Article 6, number 3, basically deals with sending things to county commissioners. Now, unless you feel it's critical that be done right now, what I was saying is that in the normal process, those kind of things are done later. After you decide what goes on the ballot, what doesn't, things that are left off the ballot, you then work on what bubbles up to be a recommendation, what just gets ignored.
Will Tricia corner those items so that we know that they don't get overlooked at that point?
We will do that. We are responsible for keeping those things in our. So, I did want to bring up, can I get you in that from? And the other thing that you found on your desk, which is under issues to bring to the public hearings, I raised it last time, the possibility of doing a questionnaire. So what I gave you was a draft of a questionnaire, and in getting ready for this, I went back through all of our minutes and found that we have had 49 comments at our public meetings. But then when I took out people that have spoken more than once and did it just on an individual, we really have only heard, believe it or not, from 20 people, which is pretty amazing. So this questionnaire is an attempt to broaden the input. And it says it's two things, getting input and also an education tool. So it's a way of letting people know that the charter's around, what it is, publicizing our public hearings. They can go online, and Steve, you're going to work with that survey monkey piece. And then, or they can fill out the questionnaire 2 ways. When they come to the public hearing, if they don't want to speak, they can fill out the questionnaire, hand it in. Or they can, if they don't come to a public hearing, they can fill it out. So I gave you a couple of sample questions. It shows you how, under county commissioners, you can deal with a whole bunch of things. How many, one part-time, full-time, elected by blah, 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 etc. So then, and the second sheet, then they fold it up in a trifold, and they have to put the stamp on, and mail it back, and let them know who their commissioner is in their district. And then this other comment section will be much larger, but for this copy, I put in the proposed budget. I've talked to the Daily News, and I told you they will send it out to the Daily News Gazette and Forks Forum, which covers 22,700 households. Port of Call will insert it, and that's 10,000 for that one. So we would print 33,000, which would give us 300 available to hand out at our public hearings, which is $22.95 plus tax. And then there's an insert rate, and then Gail just told me he'd take care of the shipping cost. You could either have it printed on white, or you can spend a few more dollars and print it on a bright sheet, so kind of like this, it would show up. So I want to know if you think that is worth doing, and if it is, the executive committee would be happy to work on translating what we voted tonight into a sample questionnaire, and start talking about getting it printed. So,
Do we have any money for it?
I don't see.
just a minute, Maggie's asked the question. We can ask for money. Historically, the Charter Review Commission has always been given $10,000, and we've only been given $5,000, so I would not hesitate to go back to commissioners and ask for another 3 or 4.
Because on the monkey, whatever it is.
Survey monkey.
All I could think of was the monkey in the trunk on the Facebook. But anyway, we talked about it, and it costs money, and some of it's free to a certain point, and then you have to pay.
Okay. And I would need to get those estimates.
Yeah, if we go over so many questions, it would cost.
Okay. And we could get those estimates and put them in the proposed budget. But I would not hesitate to go to the commissioners and ask them for a few more $1,000. We're into giving away money these days, so might as well give it to us.
Yeah, we might as well get some.
Yeah. So, but I need to know if there's any consensus that you want us to move forward on this as a way of getting the word out that the charter is meeting, and here's some of the issues, and be able to give some input.
Is that before you guys do the 3 of you make up a list, or just?
No, we work off the list that we voted on tonight.
But you 3 are going to compile,
We're
this
gonna-
is going to be inserted or mailed or surveyed, or?
I'm going to ask my executive committee to work with me to create the questions. So, Nola.
I want to go on the record that I don't think it's a value-added activity. I think giving them an agenda of what will be at the public hearings might be okay, but I don't think the questionnaire is necessary. Getting their feedback, then I don't, if they're not interested enough to come to the public hearing, they're not interested.
Not everyone can come if they work 2 jobs and have young children or have
Some people are watching
So,
your videos now,
Yeah.
which you're picking up more people.
yeah.
So I think it's valid.
Especially if you look at, most people who come to us have time because they're retired. So I think we need to look at the working families. So Ken?
Surveying people, surveying the people in the county, if it was done properly, would be a very valuable tool. I guess I don't have a lot of confidence in SurveyMonkey because there's no control for it, and the second, so first off, how you survey to have really meaningful results is an art and science. There's a specific way to do that, as well as how you ask the questions. And questions in a survey should always be asked with the expectation of getting an affirmative answer. So the questions have to be phrased that way. And I'm just concerned that none of us here have the expertise to actually do that.
We can find it.
And I think the tallying with
Okay,
others.
this meant Noah. Ron?
Well, mine does not relate to the survey because mine, the hand was raised before that.
Sorry, I missed you, okay.
It relates to what Mike was saying, and that, something about we're going to be putting proposals to the county commissioners. Now, maybe this can wait, but I think that that issue of salary commission, I would hope that that doesn't get,
Those things will not get lost. We will address what's going to the county commissioners later,
okay.
after the public hearings are all done. That
That's
will
all
be
I wanted.
part of our agenda. So, okay. Okay. Well, anyway, any other comments?
Can we maybe vote on whether we want to go forward or not?
I am trying to get us there. I am trying to give everyone a chance to ask their questions and be heard, so it's hard to do both. Go fast and allow everybody to have their input, so.
I have one question.
Yes, sir, Glenn.
I was just curious, did you try this before?
Yes, we tried it before, and we got 2,400 responses.
Oh, that's worth doing. Yeah.
Well,
Is
only
this
if they're-
33,000
if they
number
uniformly
correct?
represent.
33,000 is
I
correct.
guess you could weigh it however you want.
I know.
That's half the county.
I mean,
That's the problem.
Did you hear what
You can
Trish
weigh it
said?
however you want.
Okay, we need to,
I'm sorry, go ahead.
all right, you guys are telling me to hurry up, and then we have one side
What
more
did Trish say?
conversation. So-
Trish is
Trish is asking about 33,000 as the correct number. It's 22.7, they're very precise about that, that goes into the PDN, the Gazette, and the Forks Forum. And then Court of Call said they would put 10,000 in their distribution. So it comes out to 32.7. We'll print 33 because it'll give us 300 that we can hand out when people come to the hearing in case they don't want to talk, they at least can fill it out.
It seems really large number to me.
Isn't that wonderful?
Not really.
Not if
Well,
one person has 10 of them.
Last time we sent out over 40,000, because we sent them out, in fact, if we'd been able to put them into the utility bills like we did last time, it would have been 40,000 just for the PUD, and another, I forget how many thousand to go with the city. So this actually is fewer than we did before, but it was pretty exciting to get 2,400 back, but last time you either mailed it back or nothing. Now you have a choice of doing SurveyMonkey or mailing it back, so hopefully the mail back rate will be a little bit lower. The other thing you can do, Ken, I know you've been concerned about validity, and there's no way we're going to guarantee that, but one thing we could do is there's a place for the return address, and if people complete the return address, that will go in one pile, and if people send them in anonymously, it'll go in another. We will calculate, we'll tally them both. We will say, these are the ones that people, we know they only sent in one because they have their name, and then if you're worried about someone filling out 15 or 20, the anonymous ones will be tallied, but you know that they're anonymous. You could do something like that. Anyway, so Glenn,
I was just curious, what did you do with the 2,400 when you got, did it make any difference as to what you put on the charter? On the ballot?
well, it did give us a lot of input as to what we're considering. In fact, I have actually a whole file here of the questions.
So you got a reaction?
So we did, and the most important thing I think was that it showed there were 2,400 people who cared enough about the charter to fill out a questionnaire and send it in. So it really was, I thought it was a big plus for an education piece.
Actually, you don't even know
Okay.
that for a fact, that it's 2,400 different people. That's the problem. You don't know that. You just don't know that.
There are
I'm sorry.
some
You
things
just
in
simply-
life, that's right.
Well, I mean, what's the value of if you can't, if there's no control and you have no idea of how to gauge the input for whether it's representative or not? I mean, it just seems like a waste of time, but that's okay. I'm a minority, so.
Well, I don't know what you are. Are we discussed this enough that we can go for a vote? Because I need to know, because if we want to do it, I'm willing to go to commissioners in a week from Monday to ask them for the money, and we need to start working on creating the questionnaire.
Was there a motion?
No, there's not.
Oh, I make a motion that we do a survey. I second.
Okay, moved by Maggie and seconded. I think there's probably been enough discussion. We don't need to have any further, do we? Okay, those in favor of doing the questionnaire, 1, 2, 3, 4, 5, 6, 7, 8. barely made it, okay? Thank you very much. We'll work on that for you and get it back. Okay, we are down to our last little minutes, and we have a second public comment
No,
section.
we have to revisit,
Revisit the subcommittee.
revisit our
We did that.
subcommittee structure.
We did that.
You missed it, no one.
We did it.
They just went.
I was gonna suggest that we just ignore it because I didn't like us going.
Well, we already did that. We already did it. Because I had it written down on my agenda. Okay, so we are supposed to adjourn in 7 minutes, so I'll give you all guilt complex out there, but we're call for public comment. Yeah.
Journey to cut that off.
All right. You can stay longer. Okay, Dale.
Hi, my name is Dale Wilson. I live at Post Office Box 817, Port Angeles. Madam Chairman, one of the things I wanted to suggest about the mailing of the questionnaires, I hope those figures you got are only for people who live in Clallam County, because they do have circulation outside the county, and we don't need to send Jefferson County our questionnaire. Wanted to revisit the concept of the grand jury for a second, and all of you will have most of what I'll say right now in your folder here, but some things that require some really interesting or interested study, and that is that grand juries were a part of the American landscape for most of the history of our republic. And it has been in the recent 100 years that they have gravitated over to being run by the judiciary or being run by the prosecutor's office. So let me, and forgive me for reading this to you, I know you hate that, but I'm going to be quoting Justice Antonin Scalia, Supreme Court Justice, and I dare not misquote him. And I'll tell you when I start quoting him, but the most important thing about the fully functioning independent grand jury is that they operate as a separate entity. They are not supervised by the judiciary, and they are not an extension of the prosecutor's office. They are, as stated by Justice Scalia, a fourth estate. Justice Scalia had even more to say in defense of the independence of a grand jury. In Supreme Court case United States v. Williams, Justice Scalia, writing for the majority, confirmed that the American grand jury is neither a part of the judicial, executive, nor legislative branches of government, but instead belongs to the people. It is, in effect, a fourth branch of government governed and administered to directly by and on behalf of the American people. The grand jury is mentioned in the Bill of Rights, but not in the body of the Constitution. It has not been textually assigned anywhere to any of the branches described in the first 3 articles. It is a constitutional fixture in its own right. In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. All of that is direct quotes from Justice Scalia, and he goes further to say, quote, "Thus citizens have the unbridled right to impanel their own grand juries and present true bills of indictment to a court, which is then required to commence a criminal proceeding. Our founding fathers presciently thereby created a buffer the people may rely upon for justice when public officials, including judges, criminally violate the law. The grand jury," and I'm still quoting, "the grand jury is an institution separate from the courts, over whose functioning the courts do not preside. We think it clear that, as a general matter, at least, no such supervisory judicial authority exists. The common law of the Fifth Amendment demands a traditional functioning grand jury. Although the grand jury normally operates, of course, in the courthouse under judicial auspices, its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the function of the grand jury has generally been confined to constitutive one, calling on grand juries, administering the oaths, and so forth. The grand jury can investigate merely on suspicion that a law is being violated, or even because it wants assurances that law is not being violated."
Dale, your 3 minutes is up, but we all have a copy of your report.
And let me just add one thing. Some of you may be concerned about how this would pay for itself. I draw your attention to the culmination of the business incubation project. When they folded and closed the doors, there was $750,000 debt somehow put upon the backs of the county taxpayers. We don't know how, nobody can tell us how, but it is strange that $750,000 is now being paid at $48,000 a month, And we don't know how to get out there and be a great job for the grand jury.
Thank you.
Unfortunately, it's past its prime.
Anybody else in the audience that didn't sign up but would like to make a comment? Jerry?
Jerry said, live at 46 Courthouse Lane, Clallam. If you're going to put the survey in the PDN and the Gazette, you might want to check with them and see how many of their subscribers now do it electronically and they don't receive a paper copy.
These are, I've talked to the paper, that's how many copies they send out.
Okay, how about all the people that do not get a copy, they read it online?
So you're asking, so I should check with the PDN?
See if there's some way they could, yeah, you can convey the form to them.
Okay, thank you.
Yeah. Thank you.
Okay, anybody else? And Jerry, your address is?
46 Courthouse Lane, Clallam.
Thank you. Anybody else who hasn't signed up would like to speak? Okay, hearing none? All right.
Thank you for the opportunity to speak. My name is Charles Crane. I live at 336 East Woodby Avenue in Port Angeles. You can't explain a lot of things in 3 minutes, but you can give it a good start. If you all are really interested in the importance of what a grand jury is for Port Angeles, instead of everyone being funneled through a traffic court, you're going to have to read up on it. And there's a website where all of this has come to a head, and it's fully explained. It's all legitimate. Nobody's trying to scare you into something, and there's nothing to be afraid of. This is where freedom lies. Free speech, free information, and it's really one of the last threads of justice you have in this country, based on its origins. And until that's taken away, you might want to look into it. There's a website, it's called National Liberty Alliance.org. And they can tell you everything that you do. There's a lot of sidebars on there that you can really get to the root of all this and keep up with the current growth of it. But it's coming back. Nobody's getting away with nothing here. There's no free energy in the universe. You get out of something what you put into it. And it's always been that way, and it's always going to be that way. You're not going to get a free gift in this justice system. If you want to know what your rights are, you have to look at them. If you want your life back, you have to take it back. And that includes your freedom, and that's where that begins. I'm no teacher, I'm not talking down to you guys. You people are what we have to work with. And if it takes your consideration to understand some of these things, you need to do that. We can't tell you everything there is to be involved with this in 3 minutes. I know I can't. And, it's something that you'd really be blessed with. There's a lot there that you can work with to help people, keep people out of jail that don't need to be sitting in there and stirred until they get to see somebody. There's a lot of offenses. There's no crime without a victim, and the state can't be a victim. The state has made a lot of money getting paid the victim to a lot of offenses of statutes and ordinances. Really unfair. And that's how we got where we are. You want your country back, you gotta take it back. And then the grand jury will get there. So that's all I have to say, and thanks for this. And I hope with your help we all get a little further than we are now. Thank you.
Thank you. Anyone else? Okay. Seeing no further hands, we'll go ahead and move back to it's 9:30, and our bylaws say that we're supposed to adjourn after 3 hours. So before we adjourn, do you have anybody around the table that has anything for the good of the order? All right. So next meeting will be here, and we will hear back from the committees that have been formed around the grand jury, the Charter Enforcement Commission, and I'd encourage all of you working on your pro and con statements for the things that are going to the public hearings.
Grand jury right here. Don't go anywhere.
We nominate Sue for the other.
You're right.
For the Charter Enforcement Commission, I think Sue,